কি অনলাইন করে দিল জানেন লাইভ আছে
During COVID situation, there was no AGM held. We approached the learned single judge saying that there is a provision for which we are, and the coordinate bench has also passed an order allowing the others to appear. But the learned single judge refused to pass an order in our favor. So
Once the election process is on, that has been notified, whether we can.
my lord, this is not under the representation of people, sir. This is not.
Not of the representative of the principal is the same.
My lord, but here, my lord, here the notification has been issued. We are not challenging the notification because there is a clause over there which says that you have to attend 2 annual general in the previous 5 years when there was no AGM held.
Get it listed to my.
May I please, Your Lordship, my lord, with the consent of the other 5, my lord, I beg to mention item number 1313, my lord. The senior counsel has some difficulties today. After 1 minute, my lord, my turn will be next, my lord. Next,
A joint request, the other side is.
yes,
ready.
consent is taken, my lord. I have taken the consent.
On the joint request of the parties, consent for the appellants as well as the respondent. I did adjourn to so and so, your date आप कह रहे हैं, okay.
Obviously.
After a week's date.
Oblige.
May it please the Lordship. I beg to mention item number 16, Lordship, with the consent of the other side, Lordship. At least 10 days may be granted, Lordship, to file an additional affidavit.
You want to file some
Additional affidavit, Lordship.
additional affidavit?
Lordship.
Okay. The request is made on behalf of the, and counsel for the petitioner to get to grant permission to furnish additional affidavit. Permission granted, list on so and so.
Lordship, the case is already listed for hearing, basically. Pleadings were completed.
So you are objecting to it?
Additional affidavit, yesterday they have informed us that they will be taking time. We don't have any objection with regards to taking time, but as after pleadings have been completed, they are seeking permission to file additional affidavit, which.
Lordship, there is
Okay,
some,
permission granted to file an additional affidavit, subject to the objections raised by the counsel for the other side. You may raise your objection, consider it.
Much obliged.
obliged. May it please the Lordship. Lordship, with the consent of the other side, I beg to mention item number 4 and 5, Lordship.
4 and 5,
Yes, your Lordship.
you have the orders matter,
Admission, Lordship.
admission.
Yes, your Lordship.
Yeah, what do you want?
Lordship, this, I want adjournment, Lordship. This matter may fix any other date, Lordship.
Which day?
Your lordship may fix it on 22nd, your lordship.
22nd?
I am for the appellant, your lordship,
22nd.
22nd.
So you are also agreeing to it?
Yes,
Lord.
your Lord.
A request is made on behalf of the counsel for the respondent to adjourn the matter. When counsel for the appellant has no objection, list it on so and so.
Lordship. Deeply obliged.
Obliged.
daily list for orders item 1
My lord, this is the matter regarding acquisition of land by the government during the year 1960 to 63 for construction of national highway. A large number of communications, interdepartmental communications were made, but till today nothing is paid. Learned single judge, mainly on the ground of delay, that you have approached the court late, that is the
50 years delay.
My lord?
50 years delay.
No,
50
delay, my lord, delay, we are not only the responsible. First thing, 1962, at that time, people were not so aware.
The land was acquired as per the appellants, the land was acquired way back in the year 1962 and for the compensation, you approached the respondents for the first time in the year 2010 only.
2000. Earlier there are communications, but in written communications we have nothing.
If you
But here one thing, Lordship,
keep on making communications, how it matters.
my lord, one thing, Lordship, a large number of communications were made.
If a party is sleeping over it, his or her rights, then how can we help it?
No, the government is also responsible for that because since the year 2015, they were communicating. They are communicating each other.
The learned single judge has also raised some doubt about the genuineness of the documents on which you are heavily placing reliance.
My lord, let me satisfy your lordships. First thing, if there is any doubt about the genuineness of the annexed documents, that may be duly inquired. Do you have no objection?
That is, you have to, first of all, you have to prima facie satisfy the court.
Yes, definitely I am satisfied. Whether lordship would hear the matter today or on another, because today it is listed for order. My lord,
Whatever you want.
and let it come kindly on 9/2. 9/2.
Sir. At the request of the, so it is listed for what purpose today? Orders?
For orders, it is today listed that today.
Why did you done?
The matter is already admitted in August 2023. Will listed in due course for hearing.
No, my lord, kindly let it be fixed on 9/2 because we have been deprived from our legally entitled communications.
You have been deprived from last 50 years and now you have urgency.
Because for that matter, as Secretary of Lordship, we are not only responsible, they are making interdepartmental communications
Is this matter for hearing?
on 9/2, if possible.
Not on 9. 11th on 5th of March.
Obliged, my lord.
Item number 2 and 3. In this case, there is a connecting matter, lordship, at item number 22, 23, 22.
That is Jayant Hajarika.
Yes, sir. No, it is Hidenya Kumar Goswami, item 22, lordship.
Item number 22.
22.
Yeah. Pranay Kumar Goswami.
Oh, I think I know this is better. But tell me for me, for this time, there's a new tool.
Yes, Mr. Counsel.
Yes, sir. May it please your lordship, my lord.
Essentially, you are challenging a revenue entry
Yes.
which was made on the basis of an order passed by one of the authority.
Learned
That
it?
one of the authority,
Yes.
the revenue entry was changed as per the order passed by one of the authority. Revenue authority. And that revenue authority was changed pursuant to the Board of Revenue judgment way back in the year 2005.
Correct, my
We
lord,
have
but
not challenged that
I
order.
was not a party. That's why I just
Maybe
like
you
to-
may not have a party.
No, I'll just address your lordship, what has really happened. Because we came later on, we knew only when a notice was served to us, public notice was served to us, eviction notice. then we immediately moved before the learned single judge.
Is it correct that that entry was changed on the basis of an order passed by the Board of Revenue way back in the year
That-
2005?
But entry when the correction of records was made in 2022, my lord. No, we were not aware of it. That's the whole case, my lord. We should be aware.
May not be aware of that, but
That-
then first of all, whenever you came to know about that order,
No, we,
you should have challenged the
no, we
order.
file a writ petition before this honorable court. We file a writ petition.
When?
We file immediately when we came to know
You came
about
to
the
know.
action.
Certainly, we have no objection about that.
No, yes, about the board.
But why you are not challenged that very order on the basis of which the revenue?
No,
was changed?
we made a review application board of revenue once we came to know.
what
That's number
happened in
one.
that? What happened in that?
No, that is pending before the board of.
Pending, let
No,
them decide, sir.
No, your lordship will kindly.
So you mean to say that revenue before the Board of Revenue review application is already pending?
It's pending.
And then we'll pass an order on the.
No, what
merits of the
I'm
case
saying,
or
my-
what would,
No,
that
kindly,
review?
kindly just see, my lord, kindly what has really has happened in this case, my lord. Why it made us to come up before this honorable court. My lord, first, when we came to know a public notice has been issued for evicting us from that 101 because of land where we are occupying it. Immediately, we came up before this honorable court by way of a writ petition before this honorable court. And our whole case, we projected before this honorable court on three different acts that we are particular covered by three different statutes. And ultimately, an interim order was passed by this court, my lord, stating that no coercive measure will be taken. In the meantime, the government comes with an affidavit. In the affidavit, they have stated already a learned single judge of this honorable court has decided the matter. Has decided the matter relying on a judgment of the Assam Board of Revenue.
Yeah.
And one of the legal aids, then we came to know. Immediately, my lord, what we have done, we immediately came up before this writ court by filing two applications, one leave to appeal, which is before your lordship, and one is condonation of delay. We said, we have not made a party before the learned single judge. We were not aware. Two of the proceedings, we are not aware of it.
So who approached the learned single judge?
We approached the learned single judge. We approached the learned single judge on the basis of the eviction notice.
Because that one of the proceeding, I think they were not. Leasing because
Just come to this page number 7 of the internal page of this interim judgment.
That's what your lordship is taking up, which application?
This application,
Appeal.
item number
22.
item number 22.
22, my learned friend is appearing.
What will happen is this explains. We were the recorded substandard. And they claim to be tenant, agricultural tenants under us. And it is my name that has been struck off.
Fine.
Now, my lord, if my name is struck off, my lord, the rights of the tenant also fizzle out automatically, because why they are here to seeking a leave to challenge the judgment.
Judgment of
Judgment passed in my writ.
your writ petition.
Yes.
How can it? How, Mr. You satisfy us? What's the wrong with that judgment of the learned single judge? You are the writ petitioners.
I was the
Yeah, what's wrong in that order? You have not even challenged the Board of Revenue's order on the basis of which the entry was changed.
I'll just take the facts, the background.
Yeah.
Now, my lord, we were, I'll just.
Lord, my ancestors were recorded owners of that parcel of land. Measures around 101 bighas. Now, out of those 101 bighas, my lord, a few persons claiming to be agricultural tenants under me applied for acquisition of ownership rights in respect of those 17 bighas, my lord. My lord, here we are covered by a special statute which says that agricultural tenants can apply for ownership rights. My lord. Now, that ownership right was vested on the agricultural tenants, my lord. Against that, my lord, among the many pattadars or the recorded owners who were there, one of them approached the Board of Revenue and he pointed out before the Board of Revenue that in fact notices were not served on the recorded owners. Few of the recorded owners had already died in that acquisition proceeding. So the Board of Revenue virtually held it in favor of the recorded owners, holding that the entire proceeding was a nullity because you served notices on dead persons. My lord. In that judgment, the judgment was otherwise in favor of the recorded owners, my lord. A passing observation was made that this possibly could be what is colloquially known as niskiraj, as in land belonging to religious institutions, my lord.
Was the observation or?
My lord,
what
I'll
was
just
what
place
is the
that.
objection? That was against the original Katedats.
Yes, in fact, my lord,
Then why we have not challenged them?
now, my lord, first of all, I'd say, my lord, number one, the writ petitioners were merely co-pattadars. They were not even privy to those proceedings, my lord. One particular pattadar had gone. That judgment, otherwise, in my humble submission, was not binding.
Ultimately, if any passing observations or whatever the order is adverse to you, you are supposed to challenge it.
Well,
And even in the writ petition, you have not whispered a word about it.
No, we've done that. We've done that. In
You
fact,
challenge that.
we've not challenged that, my lord. And, my lord, to answer that
Without
specific query.
challenging, without questioning that order, you want that order be passed in your favor, despite that the Board of Revenue order is still in existence.
My lord, I'll answer it this way, my lord. First of all, my lord, I could not have challenged that judgment, my lord, because of that principle that if the judgment otherwise is in favor, a mere finding cannot be challenged, my lord. That's number one. And number two, I would say, my lord, I need not challenge that judgment because that judgment would not be even binding upon me because I was not even a party to those proceedings, my lord. Now, my lord will.
So this item number 2 and 3, these are the application seeking leave to file appeal.
Yes, correct, my.
Okay. We will consider,
Yes.
we'll grant you the leave and then we'll hear all these matters together, whether this item number 22 is admitted or not.
Yes, my lord.
Admitted. Okay. Okay.
Lordship, I have only one submission to make. In item number 2.
Yeah.
There is a writ petition also tagged with.
Yeah.
What my learned friends client, they are challenging the writ appeals order where they are seeking leave. And at the same time, they are challenging the subsequent order of the district authorities to remove them against the same cause of action before the learned single judge.
That learned single judge, they have approached the learned single judge for leave.
In
What
the
leave they are claiming there?
in the leave, I have no objection. But regarding the writ petition, Lordship, it may be sent back to the learned single judge because we do not want to lose one of the.
Which is
order.
this 12990?
Item number 3 may be reverted back to because the learned single
5946.
judge did not send it here. It is on there making a mention.
2990/2023.
5946.
5946.
5946.
It may be remanded back to the learned single.
My,
judge.
I just
In
give
that, in this 5946, what do you have prayed for?
my case was that a public notice was issued for evicting me from that land. But
That
in
is a
view of,
separate cause of action.
in view of the judgment that has been passed by the learned single judge, which is
We'll
before
examine,
leave.
we'll examine,
Now,
but
my lord,
ultimately,
I just,
this writ petition number 5946, that has to
My
go
lord,
before the
what-
learned single judge.
I just pointed out before the learned single judge.
Yeah.
And I told the learned single judge with great respect that this is a situation, we filed an appeal before the division bench and the matter is before division bench, leave to appeal. And one of the matters where my learned friend is before this honorable court. So either, my lord, the learned single has to agree to the order passed by learned.
Learned single judge has referred the matter.
No,
to
what I said, but learned because the master of roaster is your lordship. So I just mentioned it. I mentioned it before the learned chief
Because-
justice.
We'll do one thing, we'll grant the leave.
Lordship, I have no
Hear the
objection.
matter number, item number 22 and this item number 2
Yes,
together.
yes, Lordship.
And so far as regarding this writ petition is concerned, let a single judge take a view, then if you are aiding by that, then you.
But that's why I thought I should point out before this honorable court. That's why I told the honorable court that this is a proceeding pending. So my island
Consider.
judicial propriety maintains that the same judgment has to be passed because there is no alternative. Learned single judge said.
Even the single judge can take a different view also.
I'm sorry,
He can take a different view or
I-
take it to the larger bench.
my
Whatever it-
different
Lord.
different view, my.
Let your writ petition be decided on on its own merit by the
But-
learned single judge, then we'll consider.
Well, that's fine. Well, I thought that because the judgment, because relying on the judgment of the learned single judge
Yeah.
who has passed that order.
Yeah.
That's why I mentioned it before this on division bench.
You argue it before the learned single judge, then we'll consider whatever the order will pass. लिखिए, इसके अंदर item number 2 में लिखिए. Matter comes upon for consideration of application preferred on behalf of the applicants with the player seeking leave to challenge the order passed by the learned single judge. Item number 2. Okay, fine.
Two applications are there. One is delay application.
This one,
Come on,
this item number 2 is this.
Number.
Have you, matter comes upon for consideration of application filed on behalf of the applicants with the seeking leave. Seeking leave to challenge the judgment and order dated 17/1/2023 passed by the learned single judge and writ petition number 3003/2022. Full stop. Having heard the learned counsel for the parties, we are of the view, we deem it appropriate to grant leave to the applicants to challenge the impugned order. Full stop. Let this petition be listed, this appeal be listed, the registry is directed to. The state has no objection, na?
No objection, Lordship.
उसमें लिखा ना seeking leave to transfer, having heard the state council has no objection to. No objection if leave is granted to the applicant, hence the application is allowed. The applicants are granted leave to challenge the impugned order. This appeal along with appeal number 388/2023 for hearing in due course.
My lord, 1 second. There is a delay application has been filed also along with that. Continuation of delay. That has to be condoned, my
Is
lord.
there any delay?
Delay of 238 days there is delay.
230 days.
38 days.
Seeking leave to है ना करते ना उसके अंदर लिखना matter comes upon for consideration of application number so and so, writ application number so and so, seeking leave to challenge the impugned order dated, उसका details भी लिखवा दिया ना, the order dated so and so. Full stop. Another application is filed
Which is IN number
seeking
336.
condonation, IA number so and so, seeking condonation of delay in filing the application, in filing the application, seeking leave to file appeal. Full stop. Learned counsel for the state has no objection if the delay in filing the leave to appeal is condoned and leave is granted to the applicant to challenge the impugned, to the applicants to challenge the impugned order. Full stop. In view of the above, the application for condonation of delay in filing this leave to present leave to appeal is granted. The application seeking leave to challenge the impugned order is also granted. Full stop. List this appeal along with appeal number 388/2023 for hearing in due course.
Lordship, may
Now,
I-
item number 3 में कर देना, writ petition
one
number
second.
5946/2023.
Can your lordship, just for a moment, I'm sorry, my lord.
Fine.
If your lordship kindly see item number 5946, item number 3, my lord,
Yeah,
which your lordship proposed to send it before the learned single judge.
fine.
Just for a moment, your lordship, then your lordship will can send it.
Yes.
My lord will kindly see at page 188 for a moment. 188. 188. Why we have to
188.
188 of my repetition 5946.
188.
Item number 3, my lord. Item number 3. Proposing it to send it before the learned single judge. 188.
188.
Lordship got it, my lord.
Yes.
Now after 1, 2, 3, 4, 5, 7, on the basis, lordship got it on the basis. At page 188,
Annexure 18.
annexure 18. Public notice is heading.
Yes.
And see, my lord, after 7 lines, on the basis of the Honorable Guwahati High Court on 17/1/2023, passed in case number and order of so and so, as per direction or advisory hereby direct to vacate at the illegally constructed concrete tin house of the land, said 38 Dodge number, you're owned by so and so.
So it's the eviction notice.
That's why there was,
Essentially, you challenge this
that-
notice
that
in the
notice-
writ petition.
so My lord, in view of the judgment of the learned single judge, and now,
Let
my
the
lord,
learned single judge
there is a
make
protection which was given.
You can very well argue before the learned.
No,
single
it's
judge
fine,
that
my
you
lord.
were not
There is
heard
a
at the time, you were not party to that. That
But I'm-
the learned single judge will consider.
My lord, there is a protection which is given that will continue by division, but that's,
That,
we are-
the
we are not
protection
even-
was already given by the learned
but
single judge.
even that will,
Sir?
That protection is already in their favor,
No, that's
granted by the
okay.
learned
We
single
are
judge.
simply passing this order that the writ petition number 5946 of 2023 will be heard by the learned single judge on its own merit.
but fine, my lord, but that protection is given by division bench in respect of this also. That interim order will continue, my lord.
The protection was granted by the division bench or the
The
learned
learned
single.
single judge, when we came up before division bench, there was also a stiff
That will
resistance.
continue. We are not discontinuing
That
that.
will continue, my
That will, we are not discontinuing, we are not passing any
Okay,
order
my
on
lord.
that.
Then fine, my lord.
Lordship,
Then
my only humble submission is that Lordship was pleased to fix the matter in due course.
Yeah.
So there is some urgency on behalf of the state because these are large scale encroachment.
So you move an application for that, we'll consider. it.
Deeply
Move an
obliged.
application
I'll
for
do
early
that.
listening, we'll consider.
Highly obliged, Lordship.
I'm deeply obliged, man.
Yeah, sure.
Item 24, supplementary list.
Yes.
My lord, the short question that arises for your lordship's consideration is whether the B.Ed degree, Bachelor of Education degree, obtained by the respondent number 7 is valid or it's not valid. And the answer to these questions will depend on interpretation of two provisions of NCT, National Council of Teachers Education, 1993. Before I take your lordships to the two provisions, if your lordship can note down two dates. One is, my lord, 31/12/1995. This is the date on which respondent number 7 was established. And this is an admitted position.
Is the respondent number 7?
7 is Dr. Sasi Bhushan Institute of Teachers Education. The other date is 5/7/1996. This is the date on which the Assam University Silchar granted affiliation to this institute.
Assam University.
Assam University Silchar, my lord,
Yeah.
granted affiliation to this Dr. Sasi Bhushan Institute of Teacher Education. My lord, then the examination was held by the Assam University in the month of June 1997.
Month of June 1997.
June 1997. Date is
Examination
not
for what?
mentioned.
Examination for what?
Examination for B.Ed examination, final B.Ed examination.
Yeah.
On 12/8/1997, this institute applied for affiliation to NCTE. 12/8/1997.
Respondent number 7 applied for that.
Yes, my lord. On 12/8/1997. And on 30th January 2000, a provisional recognition was granted by NCTE.
That is on
That is on 30th January,
30th of January.
January 2000.
2000.
Yes, my lord.
Applied in
1997. Yes.
Okay.
And yes, this was a provisional recognition, and the final recognition was granted on 15/6/2001 by the NCT.
16/6/2001.
Yes. Now, my lord, for my purpose, only 3 dates would be relevant.
Yeah.
The first 3 dates, 31/12/1995, 5/7/1996, and June 1997. This will be relevant for the purpose of this case.
Fine.
Now, my lord, I can place the 2 provisions of the NCTE. I'll give in to your lordship, but my lord, I have this.
I have given the list of dates, Lordship, as they have stated list of dates.
Yeah, it will be there. আমার ঠিক আছে ফোন My lord, have this National Council for Teacher Education. My lord, kindly come to section 14. Section 14.
Fourteen.
14. And my lord, before I proceed, I just like to inform you, Lord. Proviso, I will seek your lordship's permission to read it afterwards, after placing 16, because that is an exception to the rule. So first I will place 14(1) of NCT Act. Recognition of institutions offering a course of training in teacher education. Every institution offering or intending to offer a course or training in teacher education on or after the appointed date may, for grant of recognition under this act, make an application to regional council concerned in such form and in such manner as may be determined by regulation. My lord, I just pause for a second and submit before your lordship that 14(1) refers to 2 types of institutions or 2 kinds of institutions. One who is offering a course or training in teacher education as on the appointed date. And the other is who intend to offer. Means they are not existing institution, but they have come after the appointed date. So therefore,
Appointed date, which appointed date?
I'll just place. This, my lord, appointed date is, I've given your lordship the notification. There are 2 notifications. First notification your lordship will see, it is 10th of July.
10th of July.
10th of July.
So,
Single page, my lord.
this one,
Yes, it's at the back, if your lordship will see, it's in English. This is 10th of July. Well, the English one is about.
Yes. So appointed date is 1st of July
That's right.
1995.
Yes,
Yeah.
and the date of the Gazette is 10th of July,
Yeah.
and appointed date is 1/7. My lord, subsection 3 of section 1 says that the central government will fix a date for on which this act will come into force. And the central government has fixed 1/7/1995. So that is the appointed date.
Appointed date.
Your lordship will have subsection 3.
Established subsection, section 3 first.
Subsection 3 of section 1, yes.
Yeah.
Yes. It shall come on in
With
force
effect
on,
on such date as the central government
That's
by
right.
notification of the appoint,
yes,
there shall be an established of the constitutionally called National Council so and so.
my lord. So 1/7 it came into force.
Fine.
Yeah. Now, therefore, my lord, I'm again, my lord, the cost of repetition I'm submitting. Section 14(1), when it says every institution offering, that means it is referring to the institutions who are already
Which is already
offering,
operational.
so they are, I will call it existing institution. Or intending to offer, they just intend, they have not offered, there's these two kinds. Then I will take your lordship to 16. Kindly come to 16. Now 16, my lord, it begins with a non-obstante clause. I read first a head note, my lord. Affiliating body to grant affiliation after recognition or permission by the council. Notwithstanding anything contained in any other law for the time being enforced, no examining body shall, on or after the appointed date, grant affiliation, whether provisional or otherwise, to any institution, or to hold examination, whether provisional or otherwise, for a course of training conducted by a recognized institution, unless institution concerned has obtained recognition from regional committee concerned under section 14 or permission for a course of training under section 15. So there is a bar, Anandana. There is a bar on the institution, examining body, to grant affiliation after the appointed date, unless the institution concerned is recognized under the NCT Act. There is a clear bar. And it starts with non-standing clause. I don't have to say. Excuse me. Now, there is an exception to this. That exception, my lords will find in Proviso 1 to 14, section 14. Provided that an institution offering a course, my lord, intending institutions are excluded in this proviso. Provided that an institution offering a course or training in teacher education immediately before the appointed date shall be entitled to continue such course or training for a period of 6 months for a 6 month if it has made an application for recognition within the said period until disposal of the application by the regional committee. So it's very clear. It doesn't need any much effort to, my lord, this thing. What it says is The exception is that if an institution is offering a course as on appointed date,
Before appointed.
yeah, on or before appointed date, it will continue. Proviso is provided it applies within 6 months, and it will continue till disposal. So there is no difficulty here. Now, what it transpires further is there was some delay in making regulation and the rules. Now, what would happen to the institution? Those institutions which are continuing with the course, whether they will be discontinued. So what the NCTE, National Council of Teacher Education, did, they extended, my lord, that 6-month timeline, they extended it. And it was extended up to 18,897 because the rules were not in force. I will just take your lordships through that extension. Your lordship will find at page 73 of my paper book. I am to draw your kind attention to the fact that according to the provisions contained under Section 14 of NCT Act 1993, every institution offering a course or training in teacher education before appointed date, that is 17, this is not correct, my lord. It's
1995.
Yes. Why it is 17.1, I'll just say the second proviso to Section 14, I have given a gazette notification to your lordship, the second one. The second proviso to Section 14, that was added later on. Huh? That happened later. Because even the single judge at one place has written this 17.8. Not make a difference, but it's not correct. This is a gazette notification, my lord, of 11th of January 2019. Second one, the first one says, my lord, this act may be called National Council of Teacher Education Amendment Act 2019. It shall be deemed to come in force on 17th of August 1995. And then, my lord, the amendments were brought for the institutions which were under the central government. And this is in the second proviso to 14, not concerned with this.
Yes.
Now, so I'll proceed now. Every institution offering a course or training in teacher education before the appointed date, I'll read it correctly, 1/7/1995, has to apply for recognition to the concerned regional committee of NCTE within a period of 6 months from that date. The provision of the said act are applicable to all colleges and departments of education in all the university offering B.Ed and other teacher education courses. It is mandatory for all teachers training institutions to obtain recognition from NCTE due to lack of information about the procedure. Many of the colleges and the departments education did not apply for recognition within the stipulated time. The procedure and the norms and the standard for recognition have already been notified in the Gazette of India by the Council. In order to provide first opportunity to non-applying colleges, the Department of Education, the last date of receipt of application to 4 regional committees of the Council has been extended up to 18 August 1997. So this was only for those institutions which were in existence on or before the appointed date. The notification itself clarifies it. Because it has not been contested, you cannot do it. Well, the notification which I have just read it out to Lordship at page 73, that July 29. This was under challenge, but it has been upheld.
Ultimately,
That
the noti, that this procedure and norms and standard for recognition
no,
were notified on which date?
it's not clear from here, but at page 239, we have annexed the regulation. And those questions I'm not raising, because this has already been upheld by division bench of this court.
We are
That
simply,
judgment, yes, yes.
we are not
You're-
examining the validity
yes,
of those provisions.
yes.
We are simply
I'm on,
just want to
yes,
again,
yeah, yeah,
just want to get
239,
information.
239, my lord.
239.
Page 239 of this paper.
Date.
Date is, my lord,
24th February 1996.
24,
February
he
1996.
is not correct, my lord. Please, I'm making my submission, sir.
24.
My lord, it is 29th of December 1995 at page
29th of
239.
December 1995.
Yes,
These
page
norms were-
239.
These, what are the norms and standards were notified by the Gazette, in the Gazette of India.
My lord, they have made a regulation. And the regulation,
Whatever the order which you are referring to.
yes, yes,
July 1997.
my lord.
It speaks about the procedure and norms and standards for recognition has already
That-
been notified in the Gazette of India by the council. Now, what is the date of these norms and procedure notification?
That is not, my lord, that's not on record.
Huh?
That is not on record. The one that I'm
Just
asking.
give us the date if you are having.
I'm not acquainted
You
with
have
that.
no
date.
idea about
No
that.
idea about it. I have no idea. Only thing, regulation we have annexed, it is 29th, yes, gadget we have annexed.
Okay.
Because I am on a different line, or different footing.
Now come to the facts.
All right. Now, my lord, the present case, as the list of data have said, the Dr. Sasi Bhushan College was established on 31/12/1995. The appointed date is 1/7/1995. So after appointed date.
Yeah.
Then recognition was affiliation was granted by the university on 5th of July 1996. In gross violation of section 16 of the NCT Act. NCT Act,
You are essentially aggrieved by this recognition or you are aggrieved by someone
no,
else?
my lord, what had happened was there was an advertisement for the appointment of principal in a higher secondary school. It's Baleshwar Higher Secondary School. We all applied, they also applied, I also applied. Respondent number 7 applied, I also applied. He was selected and I was placed at number 2. I challenged that his degree is invalid. Because,
On the ground.
yes, that's the only ground,
On the day appointed day, this college.
not an existing.
Because what did the degree was not in existence?
B.Ed degree, yes, that college was not in existence. And therefore, the degree is invalid. It's in violation of section 16 of the NCT Act. That was our argument.
Mr. Counsel, yes, there is some force in this argument, but we can't overlook the fact that the state government for the first time has notified the regulations after this appointed date for around 3 years or something.
No, not
Right?
3. Yes, yes, my lord. Yes,
They
yeah,
have
the
notified the regulations.
regulation was made on, regulation was made on 29 December
Norms and
1995.
norms and standards.
That, my lord, norms, and that was not by the government, by the NCT, they say.
NCT.
So that is,
So norms and this standard for application, for moving an application, they were not at all notified.
Just, sir. That's it. What is it? My lord, in so far as, because as I have submitted, the exceptions are mentioned under the provider 1 to section 14.
That's right. That's,
Pro-
but we.
Now, the institution was not in existence.
Though institution was not in existence.
Yes.
I mean to say that the institutions which were in existence, 1/7/1995.
Yes.
Those institutions are only entitled to move an application for recognition or affiliation, whatever it may be,
In order to continue.
and they are continuing.
Yes. And those,
Though the norms and standards were published on a later date. This is what your case is.
yes, yes, let, my lord, the
Then
act
you
came
mean to say
into,
that after 1st of July 1995, even institute established on 2nd July 1995.
that's what the law says, I have not said it.
So it's very
That's what the law says, strict interpretation of law.
Very restricted.
And 16, your lordship has seen, notwithstanding anything contained. And this, my lord, 1/7, this college came, my lord, in the month of December. By that time, regulations was already made. My lord, kindly come to 239.
Regulations.
The regulations were made.
The norms and standard for moving an application for recognition.
It is mentioned in the, this is mentioned in the,
Not
my
there.
lord, this is mentioned in the notification itself. I'll show you. Your lordship, come to 239. Kindly come to 239. Please come to 239 of my paper book.
Yes.
This is, my lord, New Delhi, 29 December 1995. In exercise of power conferred under clause F, G of section 2 of section 32 of section 14 and 15 of NCT Act, the National Council for Teacher Education hereby makes the following regulation. These regulations make all National Council for Teacher Education application for recognition, the manner of submissions, determination of condition for recognition of the institute or permission to start new course. Lordship, kindly see.
That is the procedure. They have
Yes.
provided the procedure.
Yes.
But what are the norms and standard the institution which moves an application
Now,
is to meet?
My lord, your
What
lordship,
were norms? They have not even specified the norms.
norms are specified, the forms are specified. Your lordship will see kindly next B, application for recognition. Every institute offering a course or training in teacher education immediately before 17th August 1995 shall make an application for recognition under the Act to Regional Committee in the form given in Appendix 1 of the regulation. These regulations. So, but continue. Keep the participant. Depends on it. Yes.
Yes,
My lord, your lordship has seen the proviso, first proviso to section 14(1) says
only
That-
those institutions which are in, already in existence.
can continue.
Yeah.
Provided they make application within 6 months.
And that application pending and all.
No, then, my lord, there has been a relaxation. Though it's a law made by the legislature, NCT extended, and that has been upheld by your lordship. That's all. So concession has already been granted to those who were eligible. Now, whether in violation of section 16, which starts with a non-abstente clause, not with the standing, whether those institutions which came after the appointed date,
How the learned single judge dealt with this?
learned single judge has, then your lordship will kindly come to. Learned single judge, my lord, first of all said it is covered by division bench judgment, which is not a case. Your lordship will come to page, learned single judge judgment starts at page 240.
143 also.
Hello?
It's 143 or
No, this is we are aggrieved by 240, 214. 214, my lord. Two 14. My lord, the relevant will be paragraph 35. Lordship got my lord.
Yeah.
The validity of the B.Ed degree is the subject matter of challenge. The stand of NCT became paramount importance. In the affidavit in opposition filed by NCT dated 8/8/2013, in 5221 of 2022, I think this is the case, my lord. It has been clearly stated that there was not one extension, but such extensions were made from time to time as the same were transitory period. It has also been clearly submitted that issues has been answered by the division bench in Writ Appeal 154 of 2022. By judgment dated 28/4/2023, therefore NCT would not make any comment on that. Respondent number 7 has contended that it was not possible for the institute to fulfill all the formalities when requirement under the section itself was not fulfilled by the authority. This court also noted that though the date of notification is 1/7/1995, the regional committee was constituted on 16/1/1996. The rules framed under the Act was published on 3/12/1997. This court also noticed that the procedure for recognition is prescribed only in the rules, including aspect of prescribed fee for the application. Then this is important, my lord. This court has noted that prior to coming into force of NCT Act, the B.Ed degree were granted by the institute, which was recognized by SCART on 31/12/1995. This is, my lord, in my humble submission, is not correct because this was not an existing institution. This was established on 31/12. Which was the appropriate authority at that point of time. This court also noticed that the prescribed authority, that is Assam University, has granted affiliation to the institute on 5/7/1996. Under those circumstances, whether degree of the respondent can be questioned became doubtful. 36, my lord. Notwithstanding all the aforesaid discussion, the ground tried to be protected by the petitioner. In 5221 of 2022, this court has noticed that the issue involved in the present case was exactly issue in writ petition 3214 of 2019. This is WA 151 of 154. Wherein B.Ed degree of one Govind Chakravarti, who was respondent number 7, was put to challenge. This court noticed that the permission for the by the inspector of his school, Kachar district, were given to Govind Chakravarti was a common permission dated 6966 to the respondent number 7 in the instant case, as well as the petitioner in the WPC so-and-so. The learned single judge in a judgment dated 5/4/2022 in paragraph 30 held that the degree is valid. The said judgment has also been affirmed by the Honorable Division Bench in Writ Appeal 154 of 2022, White Judgment so-and-so. I will state your lordships to the writ appeal to show that that was not the question which has been reflected in the single judge's order. Fine. Madam, may kindly come to page 8180 of the paper book. I'll take your lordships through the division bench order.
180.
180.
Yes.
The relevant will be below.
Yes.
It's at page 5, paragraph 5 at page 185.
Paragraph 183,
185,
185.
paragraph 5. What was the controversy? The top 3 lines deals with the controversy involved in the writ. The controversy that has emerged for adjudication by this court as to whether NCTE has jurisdiction to extend the date for filing of application for affiliation. This is the controversy. In this case,
Read the full.
yes, needless to say that as per section 14 of NCT Act, application seeking grant of recognition was required to be submitted to the regional committee concerned in such form and such manner as may be determined by regulation. Regulation I have already shown. Manifest such application could only have been filed as per procedure prescribed in the regulation. There is no dispute that the NC regulation was notified on 3/12/1997. This is, my lord, wrong. Because page 39, that's why I have placed this, annexed that.
Maybe the division bench was referring to norms and procedure.
No. Then let them produce norms and produce. The NCT has said, let them produce when they, what are the norms and procedure that they have prescribed?
You should at least, you should give us a date.
My lord,
You should give us a date.
My lord,
that the
from
norms
where?
and procedure were,
we so far as we know, regulation is the only thing.
You should give us a date.
My lord.
That on this date, the norms and procedure was published.
So far as we are concerned, first of all, NCT is no authority to give any norms and procedure. It has to be by way of a regulation, which was done on 29th of December, 1995. That's our, if there is anything added to that, because what your lordship will be doing with all respect,
There is
my
no
lord.
dispute that the NCT regulations were notified on, suppose it's not on 3/12/1997, any date.
It's 2912.
Before coming into force of the regulation, there was no prescribed for the agriculture to have filed an application
My lord-
seeking affiliation with the NCTE.
My lord, your lordship, that can be given by regulation only. That's what is written. Can you see? My lord, this regulation came on 1/7/1995. 6 months from that will be January. Maybe December 31st or January.
Right, you are right, Mr. Concept. But for that purpose, they have to fix the norms and standard to grant application to so and so institution who meets those norms and procedures. They have not even declared the norms and
My lord,
procedures.
the institute.
And after that is the appointed date, they later on, they found that or published that norms and procedure. So in between interim period, you mean to say that this 1/7/1995, any institution is established and thereafter they publish the norms and procedure after 3 years. In between, if any institution is there, it has no right to even apply for recognition.
My lord,
It's very hard to-
no, but law has to be followed. Even Bhupendrath Tripathi,
But
because your lordship, my lord, with all respect, if your lordship permit this, that means your lordship is reading something in proviso to 14. That people.
the para number, further para number 6.
6 of?
6 of this 180 is page 185.
Yes.
Again clarified. It's
Yes, my lord.
specifically clarified the thing.
Section 12 NCT again enjoins upon the council a duty to take all such steps as it may think for ensuring planned and coordinated development of teacher education. In our considered opinion, recognition being internal part of the duty defined under section 14, the council were definitely clothed with the power to grant extension to the concerned colleges, at least during transitional period. Let me just.
Next.
Yes, the NCT issued later on 10/7/97, 29/7/97, intimating Registrar of Assam University, Silchar, to intimate existing institutions to apply by 18/8/1997. This was to existing institution, my lord. It is further not disputed that Silchar College of Education submitted application for recognition on 12/8/1997. That is within the extended period. Thus, the institution from which the private respondents acquired their B.Ed degree, having applied for recognition within extended time provided by NCT, it was fully entitled to intake and impart B.Ed education course for the session which commenced before 18/8/97. The respondent NCT, by affidavit in opposition filed in the writ petition, has affirmed the fact that B.Ed degree obtained by the respondent was a valid degree. This position of law has been crystallized by the Honorable Court in the state of UP versus Bhupendrath Tripathi.
Mr. Mishra,
My Lord, the Honorable Chief Justice has also noticed this. You see, this judgment in page para 6 in page 85
Yes.
actually deals with the issue conclusively, except that you may argue that there is a distinction in the sense that in that case, the institution was in existence prior to the notified date, appointed date. And here, this came into effect after the notified date. That will be the primary distinction, distinguishable.
May I
feature.
add, if you lordship
No, I'm
permit me?
just putting the query
Yes, yes.
so that you can.
My lord,
deal with
yes,
it.
ma'am.
Now, 14 talks of offering or intending to offer. It does not talk about existence of an institution.
No, offering means it's existing.
No. One particular institution which is in existence prior to that date,
Yes,
but decides to offer B.Ed course after a particular date.
yes.
How can existence and offering be the same thing?
Then your lordship may see the proviso.
Yes.
Proviso 1.
Yeah.
See the proviso.
Yes,
Proviso doesn't include intending institutions.
tending in the sense, what my brother is suggesting, that institute is
Yeah.
already existing but not offering this B.Ed course.
That, my lord,
And then there is the question of existence. He is offering some other courses, and later on, he decided to offer this B.Ed course also. So that is the
My lord-
question of existence, what you are challenging it, or what you are pointing out or pressing hard, existence of institution, that is not relevant for that.
no, but what I'm submitting before your lordship is, I'm submitting strictly in accordance with law. Your lordship will have to interpret and I will follow it. That will be it. I'm just trying to project my case. And so far as writ appeal, my lord, 154 of 2022 is concerned, which my lords have just seen, the question that arose there was not about existing institutions or not a non-existing institution. The question was whether the NCT has power to extend the limit of 6 months, which is provided in the first proviso. Because
That
first
is what is there.
proviso,
Yes, it has.
so therefore I'm saying that was the only question. This question did not arise whether the extension will apply also to those colleges who were not in existence
Even
or not.
though that question was not there, but if the division bench has answered or made some observation, then certainly.
My lord, I don't have to tell.
It come within the sweep of.
My lord, I don't have to say, your lordship knows is a judgment is a judgment for what it decides and not what may reasonably flow from it. This is what I read in Sirvai some time back, long time back. So therefore, my lord, in my humble submission with great respect, if the issue in the judgment, the one that I have placed before your lordship, my lord, the judgment can be read only in respect of that issue. This is my humble submission. My lord, your lordship has to decide. I'm just doing my job.
Rule, but the exceptions are also there.
The exceptions are there. Now, Bhupendra Nath Tripathi, that's the decision relied upon.
Have you raised any objection when the applications were invited?
My lord, at the
Have you
time
raised any
before,
objection when the
yes,
applications were
before
invited for that
before
post that
the
this person, his candidature should not have been considered?
yes,
You took
we
your
have
chance.
we
You
have
took
we
your
have done.
chance.
In fact, at one point of time, his appointment were cancelled
When?
by the government. His appointment on
Once
that
upon
my
a time.
representation. Yes.
On what ground?
It was that it's not valid degree. That was the ground.
No. This appointment on the post of principal or teacher,
My lord,
his appointment of the respondent was cancelled on the post of teacher or principal?
no principal.
Principal, then
Yeah.
what happened?
Now, then, my lord, he went to the High Court.
Oh.
The High Court remanded it.
Okay,
Then the order was passed in his favor.
and the High Court has, what observations the High Court has made?
That I have only, it was remanded. I don't think any observation was made. And-
Have you placed that order?
Yes, that order is there. That order is there. That, my lord, will find at page 77.
Seven.
Page 77.
You are not disclosed this earlier.
Yes, I have, my lord, in fact, at the time of selection only, I filed an application to the selection committee. Decentralized. You are taking over working to each page one. Oh.
60, 70.
I have to go, Lali. My lord, I'll be in serious difficulty because I'm arguing a NIA appeal matter, my lord, final stage of argument since last week. In court number 7, I just took permission that there is an admission matter, I will come. So, so I'm just informing your lordship. Of course, I am at your lordship's disposal, I will. That's why I preferred.
Okay, we'll pass it over for the day.
Uh,
Day after tomorrow.
My lord, 8, 9, we've given a letter of absence. I'll not be there. On 12th, your lordship will take it up. Monday.
But the request of the council for the appellate analyze this matter on 12th. Yes,
I am going to return on 31st March, Lordship.
31st.
31st March, please.
So you want to linger it?
No, I want to, Lordship, it should be completed, Lordship.
Yes, so I could, I'm last one
He has a
week,
long
my lord, I'm
service. He has a
arguing.
long service.
Mr. He is going to retire on 31st March.
My lord, Monday.
Let it be. Then apply again.
My lord, here, on the principle, my lord, your lordship will decide. On the principle, your
Because of
lordship
the
will
status-
decide, it will be there, my lord, we will also.
Okay, we will hear.
Yes. So
Because of
Monday,
the status quo order, I am suffering, Lordship. Status quo order passing this court, Lordship, I am suffering.
How you are suffering?
Because of the status quo order, my appointment has not been issued, Lordship.
no one.
Authority has
suffered.
selected.
Appointment. When the selections took place? Selections took place on which date?
Selection took place earlier, Lordship, in 2018, Lordship.
2018. And still you have not been promoted on account of stay order.
No. He took over. Then there was an order by the authority. Then I took over. And that I'm continuing.
You are continuing.
Yes.
He has long period of service, I have only 2 months, not 2 months.
That doesn't mean. We thought you are in the, on the post.
No.
No, if he's on the post, my lord. But Monday, my lord, I'll not seek further adjournment. Your lordship, I will not seek with today because I will finish that to those cases, my lord. Since last week, I'm arguing. I'm grateful.
Lordship, I have given the list of dates. Can I take back, Lordship?
Yeah. Sure. Be prepared, Mr. Council, please. Spare some time to argue on that day.
And now I understand where you're.
In fact, as per my knowledge, Lordship, a writ appeal has been passed by your Lordship on earlier occasion. That was challenged to the Supreme Court. And Supreme Court also dismissed the SLT.
Writ appeal of.
Against the writ appeal order, they have prepared SLP with the Supreme Court. Earlier with petition writ appeal. That was also
Disposal, that representation disposal.
That is also dismissed.
We are not a party to it.
They have preferred, Lordship.
Division bench order.
Yeah, Lordship.
Yeah, that's.
We are not a party. Are we?
Well, here on 12th.
We are not a party there.
2 single bench has affirmed. Thereafter, writ appeal dismissed. Supreme Court dismissed.
SLP dismissed. Okay, we'll consider it on 12th.
Read Kamhailal.
Item 8 for hearing daily list.
Yes.
Well, here the challenge is to the rejection of the candidature of the petitioner to the post of copyist in the administrative tribunal matter. What had happened is the petitioner was serving on contractual basis, and on the advertisement being floated by the department for the certain post matter, he had approached this honorable court, and this honorable court had by deciding the repetition directed that we should be given, if Lordship will have the advertisement at page 34. Page 34, my lord. Was the advertisement. Serial number 3 is the post of copyist for which the petitioner vies for.
Page number 34, initially.
My lord, and except 12, my lord.
12.
In my copy,
Yeah,
it appears like a 39, my lord, but it is 34 actually.
39.
It appears like 39, but it is 34, page 34.
Sir, it is 39 in. Annexure 12 is 39, it appears to be 34. But it's 39.
Sorry, my lord.
Yeah.
Now, my lord, this advertisement, Lordship will find serial number 3 is the copyist post, my lord.
One post.
And then Lordship would find the examination fee part down below after the age. The second bullet, my lord. The applicants for the post of LDA, stenographer and copyist, whose applications are found in order will be called for written test examination to be held at a place and date to be notified later on. After which the qualifying candidates in the written test will be further called for viva voce, computer test and speed test as applicable for the post. Then the fourth bullet, Lordship will find the candidates having experience in judicial works or working in the judicial establishment in Assam with requisite qualification as stated shall be given due weightage. Now, my lord, since the petitioner was working in the post.
What is petition test? Why you have made party to the registrar of Guwahati High Court?
My lord, because the advice was sought from the registrar of the Guwahati High Court as to what is to be done, my lord. Lordship will have page 45, my lord.
Who sought instructions?
My lord, the presiding member, the presiding member of the MSCT sought instructions from the registrar here, my lord, who was also heading the centralized recruitment cell, my lord. Therefore,
Ultimately, he may sought some instructions from or guidance from Registrar General High Court,
my lord.
but ultimately you have not asked for any relief from the High Court.
No, my lord, because the centralized committee had advised that the weightage is to be given at the end of the board, and that is the procedure followed by the recruitment cell,
Maybe said there.
my lord.
But how this?
Otherwise,
this
the High Court is not concerned. My lord. The records have been produced by the registrar High Court. My lord, that was retained by the registrar High Court. Records have been produced by them, my lord. Otherwise, there is no specific relief claimed against him.
Producing the record, ultimately, maybe the record is also necessary.
My lord.
Not a matter pertaining to principle.
This latest notification of 14th of August 1993.
2020.
2023 clearly says that except service matter pertaining to a staff of Guwahati High Court and Samanu, all other cases pertaining to principal seat of Guwahati High Court and its permanent is the Guwahati High Court is arranged shall be henceforth be listed before the division bench of principal seat at Guwahati.
True, my lord. My lord, this matter was in fact being taken up by the learned single judgment. It was placed before the learned single judge. Then the registry, they put it up before the division bench. I had a discussion. They said that since the recruitment cell is the, it was a verbal discussion. They said the recruitment cell is there, and therefore we have to place it before the division bench. I would have no difficulty before a single bench.
Okay. In view of the application number 101 dated 14th of August 2023, the registry is directed to list this matter before the appropriate bench. In the light of the container, in view of, in the light of the
Mobilization.
Item number 9.
May I please, Your Lordship? My lord, the matter pertains to compensation of Jirat, my lord. The land was, my lord, land is, my lord, government land. And the petitioners, my lord, have been, my lord, living on that said plot of land from their forefathers, my lord. And my lord, said land has been taken for construction of railway line, my lord. And the petitioner is, my lord, paying only for the compensation of Jirat, which was standing over the government land, my lord.
Why this case is before DB?
My lord, there is a order, my lord, order dated, my lord, 14/12/2022.
22.
Yes, my lord, 14/12, my lord.
Passed by the
By this
single judge.
order, my lord, the honorable single judge, my lord, found that there is another repetition disposed of in respect to government land, so far considering the Zirat, my lord. But my lord, the para 11 of this order, my lord, the honorable single judge held that
There's no
there is
dispute.
no dispute as to the fact that this land is a government land. And my lord, if this is a government land, my lord, government perhaps cannot acquire its own land. So if the land is not acquired, so payment for Zirat would not come into, my lord. So this, on this basis, my lord, since there is contrary view by the coordinate bench, so 5.
But why is this matter? See, the larger bench can review it.
Assist. Observance. 14/12/2022. Fourteen 2022.
Other bench, it easily is given. It is not a ground. There is no disagreement. File charter. इसने बोला है हमें brother, फिर bench वाला कंफ्यूज मिल को कुछ दिखता नहीं है liberty should not have been created.
Land belongs to you.
No, my lord. Land is government land, my lord.
Government land, you
My
are
lord,
an encroacher, simply an encroacher. And you grow some trees or something else or whatever it may be,
Occupier,
you are
yes, my
seeking
lord.
compensation for that.
My lord, not for the land, my lord. Only the
Whatever the structures you have built
houses.
in or what some plants you have grown on the government land. And now you are claiming compensation for that.
My lord,
That's great. It's a good
my
idea.
lord, my lord, the government, my lord, provided electricity connection, my lord, water supply, and some license is there, my lord.
Then you
And
enjoyed
my
that
lord,
right.
they
You
are only
enjoyed, you
claiming.
enjoyed whatever your encroachment. And further, you need some compensation for that also. So the government is obliged that you have taken care of that land. Case of aapki land padi thi, somebody will take away the land. So I have taken care. So grant me the compensation.
My lord,
This is what your case is.
yes, my lord, thousands of peoples, my lord, who have been living from their forefathers, my lord, nearby Guwahati Sonapur area, my lord, and they,
If the land
nobody,
is not
nobody,
even
my lord,
acquired, if the land is not even acquired, then
my lord, the assessment has been done, my lord,
the assessment
For-
in respect of some
for the
land
Zirat,
which
my
is
lord.
already acquired. Here the stand of the government is that they have not even acquired the land.
My lord, the district administration, my lord, with due process of law, my lord, assess the Zirat value. My lord, page 12, my lord. The PWD, my lord, there, PWD building also there, my lord. The railway authority was there, my lord. Along with the district and administration, my lord. Only, my lord. Thank you. Yeah. One time.
the larger venture doubling to the contrary view.
Yeah,
My lord, they only occupy the land for their livelihood, my lord. As citizen of India, my lord,
That's
bona fide
right, sir.
citizen of India.
but now if the.
And my lord,
government-
many,
The land was government land. And
that
they
is
have
correct, my lord, that
constructed-
is admitted
They
that.
have
We are also
constructed a
admitted.
railway line there. And now you are
Lord,
claiming, so since I was sitting on the government land, I was taking care of that government land.
My lord,
As
nobody,
being
my
a
lord,
watchman or something, so give me some compensation for that. Whether the government has asked you to take care of their land.
my lord, during their occupation, my lord, nobody, my lord, come and try to eject from this land, my lord. My lord, they have been living from their forefathers, my lord. And
Mr. Ahmed, your clients are encroachers over government land. Is that correct?
that is, my lord,
No,
correct, my
please.
lord. That encroacher happened, my lord, more than 100 years, my lord.
That's all right. Is there any authority, any law, any provision of statute which permits this kind of a relief to be granted to encroachers?
That is, my lord, as per law, that is not there, my lord. And my lord, the some in the similar situation, my lord, thousands of people, my lord, in that area, they receive their compensation for Jirat, my lord. But I have also annexed the many orders, my lord.
They have encroached over the government land and granted compensation.
Land, not my lord. My lord, only for Jirat. They receive the compensation.
So it may be, the Jirat was in the government land only.
Yes. My lord.
And they remained there and they were granted compensation for that.
Yes, my lord, already given, my lord. Already given, my lord, for the Jirat.
It's very straight, sir.
Lord, I have annexed many orders, my lord.
It's like that, a tenant is sitting in tenant is, having rent, some owner, landlord has owned, this rented out his property to the tenant. And when he asks for vacation of it, he'll ask some money for that. This is what the question
We
is.
are not, my lord, claiming for the, only for damages, my lord. Houses were there, my lord, trees were there, they developed the land, low-lying land.
Encroacher হৈ গ'ল সেইটো একো নাপাবা জিলাটোত পাবা এইবিলাক একো নাই
And
So now what remains, Mr. Counsel? Now what is there to decide in this appeal? What is there to decide in this appeal?
It's not an appeal.
Or no, rate, sorry.
Yes, my lord.
What is there to decide in this rate?
My lord, only my humble prayer is, my lord, allow them to, my lord, disburse the compensation for the.
Directly disburse. What is para number 11 of the
That is
this
there, my
order
lord.
dated 14/11/2022. The learned single judge has virtually decided your rate. Have you read that?
Yes, my lord.
Yeah, read.
I
For,
read it,
for our.
read it, my lord.
Yes, please read. What para number 11 says?
There is no dispute to the fact that the land in question is a government land, and in this connection, there is a specific statement of admission
made in the writ petition itself in paragraphs 2, 3, 4, 5, 6, 7, and 8, when the description of the land possessed by the 7 numbers of petitioners have been given, and it is clearly admitted that the land in a government land. Though a statement has been made that the petitioners have been possessing the said land since the time of their forefathers. That is admitted fact. That is my fact, my lord, in that petition.
Though the statement has been made that the petitioners possessing the forefathers, the status of the petitioners are that of encroachers. Once the petitioners are held to be encroachers, any question of payment of compensation cannot arise for evicting them from the said plots of the land which is required for a public purpose. Though the order of this court in past in so and so is a conditional one, this court is of the opinion that the aforesaid liberty is also perhaps not warranted in the present nature of cases. Admittedly, the claim for compensation either for land or ziraat is not maintainable at all. The submission of the learned counsel for the petition with regard to section 17, apart from being fallacious, the same is wholly untenable. In the instant case, there is no acquisition proceedings as the government is a government land.
Yes, my lord.
That's the end of the matter.
And that is why, my lord, in that view of the matter, the registry is directed to place this matter before this court.
Okay.
Lord Zaban. And
Yes.
my lord, section 3 of the Land Acquisition Act 1894, my lord. Section 3A.
Yes.
Preliminary survey of lands and power of officers to carry out survey.
That is in relation to the land owned by a person.
Yes.
If the government is going to
My lord,
acquire a land owned
second,
by
my
a
lord,
khatedar,
provided that, my lord.
these provisions are applicable. Here the government land
Yes, my lord.
and
lord.
a single judge has made observations in para number 11 or the earlier paras.
My lord, section 3A provided that, my lord.
Yes.
No person shall enter into any building or open any enclosed port, any building or any land, my lord. Any land, my lord, there is a house, there is a private.
Sir.
My lord, only my humble submission, my lord, they are very poor family, my lord, and belongs to, my lord, tribal persons, my lord. And they have been, my lord, maybe enclosed, my lord. That encroachment, my lord, had been happened 100 years back, my lord.
So that's right. But
and my lord, electricity, water supply, everything has been provided to them.
or some
And there is some source of license, my lord.
yes. This petition is filed by the essentially seeking a relief that the respondent number 2 be directed to release the compensation in respect of Zerat plots of land of the petitioner of village Hamla Jahari, Masuja Sonpur, under Sonpur Revenue Circle in the district of Kamrup, Assam. Full stop. Initially, the writ petition was listed before the learned single judge. And the learned single judge has passed the order on 14/11/2022. Full stop. Pursuant to the observations made by the learned single judge in the order dated 14/11/2022, the matter was, the registry has placed the matter before Honorable Honorable the then Chief Justice to consider the Chief Justice, and as per the order passed by Honorable the then Chief Justice, the matter is placed before this division bench. Having heard the learned counsel for the petitioner at length and taking into consideration the observations made by the learned single judge in para number 11 of the order dated 14/11/2022, we find no merit in this petition, as we are in perfect agreement with the observations made by the learned single judge in para 11 of the order dated 14/11/2022. Hence, this writ petition, resultantly this writ petition was dismissed without having been any merit, without having been any merit.
Obliged. Item number 10.
Lordship, this matter at one point of time was at Itanagar permanent bench, Lordship.
One point of time,
It was at Itanagar permanent bench, Lordship.
permanent bench.
Yes, Lordship. From there, it was transferred to here and it got tagged along with this, Lordship, that infrastructure matter, Lordship. So the parties, councils all are from Itanagar.
So now that this has been segregated, it's all trying to speak. हम लोगों ने कहा है कि कितना से देखो तो दस तो काफी मैटर्स करें अलग कर इसके तो आपको नहीं करो.
This is a private, in fact, this matter doesn't relate to any infrastructure.
No, Lordship.
That,
Let it go back to
Lordship.
Then again, non appears to be petitioner, so and so is. Personal order dated 26/2023 passed in a batch of writ petitions. This matter has been segregated. We are informed that this writ petition pertains to Itanagar permanent bench of this court. It is perhaps for that reason that the petitioner has remained unrepresented on 2 consecutive orders. Whether as since the matter has now been segregated, registry to transmit the record to be provided permanent bench for district.
That's applied, Lordship.
Item number 11.
May it please the Lordship. Lordship will kindly peruse order dated 26/9/2023.
Yeah,
26/9.
2023.
Twenty-two or 23?
My lord, 26/9/2023.
26th of September 2023. In fact, by this order, on behalf of the state, I prayed for time for filing an affidavit. And this is a case where 3 service rules under one department, or rather directorate of town and country planning, are put to challenge on the ground that basically that the persons at the level of superintendent do not have the adequate opportunity to advance for further promotion to the post of director, which is the top level at the directorate. That is the basic ground. According to them, there are 3 service rules. Three wings are there: service, engineering, planning, and research. So for all these 3 wings, 3 different cadres are there, 3 different service rules are there. According to them, the opportunity to advance from the cadre of superintendent to the post of directorate is not there. That is the basic challenge, man. And since there is a challenge to the rules, mainly at one point of time, there are some orders passed by the court, where, in fact, the department wanted to sort out the matter. And some sort of meeting also was held, 2-3 rounds of meeting. But possibly we have not been informed about any outcome of those meetings. So thereafter, I prayed for some time, because now the matter will have to be hard on merit. It appears that they have not taken any action. So I prayed for some.
Affidavit or?
I would like to file. Let there be an affidavit. So after that, I can argue the case on merit, my lord.
Only, and only we can consider the case. Mr. D. Majumdar, an additional advocate general, seeks further, how much time?
3 weeks time would do.
3 weeks time to file. Counter to the writ petition. Counter affidavit of the writ petition. Time prayed for is granted. Response for stop. 3 weeks के बाद की date है.
Deeply.
My lord. Yes.
Obliged, the Lord.
Is it an appearance to read?
Item number 12.
Good morning, Lordship. Today was fixed for hearing. Lordship, due to my health condition, actually I will need much time. I have prepared at least 1 hour. I need to argue in this case. I need to put my points. But my health condition is very bad today, Your Lordship. My voice is also broken down. And
Need adjournment?
yes, Your Lordship. I'll be
When?
middle of March will be good, Your Lordship. For treatment, I'll be going outside, Your Lordship.
We pray for a speedy recovery.
Thank you so much,
Response
Your
also.
Lordship. Thank you so much. Thank you.
As prayed. By the land council.
Item 15.
My please. Hello, I approach this honorable court against the judgment and order dated passed by the Larned Central Administrative Tribunal, my lord. Wherein, my lord, at no point of time, my ACR has been communicated to me. That was communicated on to me only after I had approached before the Larned Central Administrative Tribunal in the year 2013. In the year 2001, 2, and 5, 6, they assessed me unfit for promotion to the post of
to the post of Assistant Central Intelligence Officer, grade 1, my lord. My lord, judgment starts from page 80, lordship. Central Administration.
H.
80, 80.
Your client is retired from
Yes.
service, 2008.
Yes, madam. 2008.
What is the date of Devdutt's judgment? Which year was it decided?
Reference is given in page 94, if the lordship will see. It's in another case, Lacetum E, Devdutt versus Union, that's in 2008, lordship. 2008.
2008. Please tell us two things. The petitioner retired in 2008 and he has approached the tribunal in 2014.
No, my lord.
Then-
Before that also, my lord, I have approached before the learned tribunal, my lord, in the year 2009, lordship. But
What order?
subsequently that was withdrawn and directed me to some materials may be collected and produced before the tribunal. On 14/10/2009, my lord, I withdrawn the same
That is
original
correct, but
application.
today what relief can be granted to the petitioner?
My lord, what happened actually in the year 2007, that is prior to my retirement, 26/12/2007, large number of ACIO grade 2 was promoted to the post of ACIO 1. But at that point of time, I was not considered for promotion.
Even if it is accepted that uncommunicated adverse entries could not be acted upon.
Yes.
Today, what is the relief you are seeking?
My lord,
He has already retired. We cannot ask them to promote you.
some
We can only
pensionary,
ask them to consider.
some,
But
pen,
today they cannot consider you because you cannot be promoted.
some pensionary benefit.
In 2005-6, you were graded as average
Average.
and for reasons have been given for that.
No, my lord, that reason was given to me only year 2013. That is 6/8/2013. After the judgment passed by the learned CA.
Ultimately, even though now if these adverse entries have been communicated to you, what is your defense?
My lord,
You were
communicated.
graded as an average. Shri Niranjan Dey frequently remain on leave during the period in question, including long periods, earned leave, half pay. The total period of absence from the duty on account of frequent earned leaves came 194, including
That-
83 non. The following achievements in raising sources contact none. Ability to access and evaluate information fair. Capacity to special tasks may not be capable for special tasks. Capacity or any other intelligence assignment, nothing specific to mention. 2001 to 2002 की तो ये आपकी
That was treated as dice non-lordship. And if lordship may kindly come to page 84 only, my lord. It is very much clear. Paragraph 4, my lord.
84.
84, lordship.
Yeah.
Page 84 of the judgment.
Yes. What are you referring to?
The applicant has contended that uncommunicated ACRs ought not to have been used to his prejudice, and therefore the findings that the applicant was unfit for promotion do not stand to reason. Further, the applicant has pointed out that adverse ACR in the case of ACR for 2001-2 were communicated to him after 12 years.
So
And-
your argument.
Yes, it is my argument.
What's the finding of the
Finding
argument? You can argue. That's the thing.
And in fact, my lord, on the similar facts, my lord, Honorable Justice Ujjal here has passed a judgment, my lord, if lordship may kindly peruse it.
First of all, assail the impugned order. It's simply a petition. The tribunal has passed the detailed order and starts from number 7. From the facts inputted, the basic and primary question that the tribunal is required to answer is whether a memorandum dated is legally tenable or otherwise. Now they have given their finding. How you are aggrieved and how this finding are and in the eye of the law. Then you argue it out. Covered है, कपट से covered है. Another thing that this non-supplying of adverse ACR is not be accepted. But at least now the tribunal has thoroughly considered your case and they have given some finding. Now, what is the challenge to those findings?
Yes, submit the presentation again here.
Yes, Mr. Gonzalez.
My lord, regarding the OM, my lord, my lord, even in the case of OBG, was those my lord, herein also law otherwise. I just pointed out on that portion only.
Which portion?
That uncommunicated adversary. That is also.
It's why only uncommunicated references that tribunal has allowed, disposed of your earlier way, granting you the liberty to move representation that you moved in representation and pursuant to that, that has been decided in the year 2013. And ultimately, again, you have challenged that memorandum, and that has been upheld by the tribunal after giving reasoning. How the reasoning given by the tribunal is bad? Show us. Otherwise, how can we interfere?
Only thing is that, my lord, everywhere they have stated that there is no wrong because I was given the gradings of average. In both the, my lord, DPC, 2001, 2 and 5, 6.
That's all. Anything else?
No.
At this petition, the petitioner has challenged the as assailed the order dated 13th February 2017, passed by the Central Administrative Tribunal, Guwahati Bench, Guwahati, hereinafter to be referred as Tribunal, whereby the OA filed by the petitioner against the memorandum dated 20th of December 2023, passed by the respondent department, has been dismissed. Full stop. The petitioner was working as assistant Central Intelligence Officer, grade 2nd, / general, under the respondent department. He was superannuated on 28th of February 2008. However, approached the tribunal, the tribunal in the year 2012 with the prayer to upgrade the adverse entries made in the service record of the petitioner pertaining to the year 2001-02 and 2005-06. Stop. The OA filed by the petitioner before the tribunal came to be disposed of with liberty to move appropriate representation before the respondent authorities for upgradation of aforementioned adverse entries. Full stop. The representation filed by the petitioner was ultimately dismissed by the respondent department wide memorandum dated 20th of December 2013, which came to be challenged by the petitioner before the tribunal. Full stop. The tribunal has dismissed the original application or OA filed by the petitioner by impugned order while making certain observations which are reproduced herewith. This quote is para number 11 to 17 of the impugned order. Having heard the learned concept of the parties at length, and after carefully scrutinizing the record, material available on record, we don't find any case for taking a different view as taken by the tribunal. Hence, there is no merit in this. The petition, the same is therefore dismissed.
Item 17.
Please, Lordship. I am on behalf of respondent number 5 and 6. I am not engaged counsel telephonically from seeking. My friend Alex Basnet has informed me he is unable to come here today before your Lordship. So kindly adjourn the matter today, Lordship. I
don't remember. Why was it transferred here?
Malaj, the writ of plea couldn't be heard because one of the judges was the previous counsel for the respondent.
It was an exception matter.
Yes, Malaj.
Yes, what do you want now?
conducting respondent counsel telephonically contact me. Today, few minutes ago, he know the matter. So my humble prayer before your Lord. He is not available. He is out of station.
Only one request, Lordship, because I am for the respondent number 11 to 19. Only one difficulty. I will not oppose. The difficulty is that it is me only as a respondent who are the real affected party. So I am just reaching that matter name. Kindly pick the lead date and more.
Please, yes. Which date?
11th March.
After 10 days later.
Anytime in the 12th.
11th or 12th.
12th March.
On that day, the council will come or will be available.
I will inform you, Lord.
The case is fairly covered by
He
the.
will inform you or he'll come or
He will come,
attend the
Lord.
court.
He will come.
Certainly.
He will come.
Okay, which specific date do you want?
11th or 12th, Lord.
Okay, 11th or 12th?
12th March.
March. Oh. Okay,
Because the entire promotion is expected.
At the request of the learned counsel, at the request of
Of the respondent number
5 and 6.
after presence of Mr. So and so.
1 to 10.
For council कौन है?
1 to 10.
Kesan Dicky Bhutia.
For council so and so appearing for the respondent number 5 to 6.
1 to 10.
List this matter on 10th of March.
12th March. 12th March.
12th March.
Deep oblige, Lord.
Malaj, can I pay an indulgence, Malaj? In the meantime, can we prepare a paper book for the common, because it's quite a bulky document, Malaj. So we prepare a paper book for everyone's convenience and we supply it to the court, Malaj.
No, why not? इसमें क्या बात है? कुछ नहीं का मतलब है. Do it.
Yes, sir.
Item 18.
Is there adjournment, sir? One item. Covered in adjournment.
Yes. May it please the Lord. My lord, two different charge sheets were there. The first charge sheet says that, my lord, I induced some person and collected money for investment in a non-banking institution. And in that charge sheet, the other charge was there that I'm in possession of assets disproportionate to his known source of income, which ultimately was not proved because in a criminal case, I was given acquittal. That was there. And in the second charge sheet, it was stated that I created 25 vendor codes online in SAF. SAF is a software, Marat, and in his own discretion without supporting documents and approval of the competent authority for personal gain. Malad, here the charges, the replies that I made in the first one, Malad, here is that the reply to the first charge sheet is in Malad, page 86, if your lordship can turn up. Taking into consideration my limited scope, Malad, in arguing a matter in a penalty, page 86. Important, this is a reply to the first charge sheet, Malad, at page 87, Malad, the first part, page 87. If I can trouble your lordship, Malad. Page 87. May I read it, Malad? Again, it is very significant to bring out that most of the above complaints are in fact not directly under me in the chain, but under C. Archie Dinglo, MEO, IOC of Guwahati Refinery, and Rupam Shukla, who are prominently involved in enrolling investors under them. And this was the fact that I placed before the authority, Ballard, saying that.
On what ground are you assailing the judgment of the single judge? Please start with that.
The ground that I held before lordship is this in a very limited scope regarding the proportionality of the punishment. If Malad, this matter could have been sent back to the authority for a consideration, because removal, I think that it is too harsh, because as regards disproportionate.
How the learned single judge dealt with your argument? You
Malad,
please read out
the Malad,
find out any ambiguity in that.
Malad, that is at page 178. Paragraph 17 in the judgment, Malad. May I read it, Malad? The only question to be decided now is with regard to the prayer for the petitioner's counsel to remand the case back to the disciplining authority to take a decision as to whether a lesser person punishment can be imposed upon the petitioner, as the penalty of removal is disproportionate to the offence. In the case of such and such, the apex court had held limited judicial review is available for interfering with the punishment imposed by the disciplining authority. That is only in cases where penalty is found to be shockingly to the conscience of the court. Even in such a case, when the punishment is set aside as shockingly disproportionate in the nature of charge framed against the delinquent employee, the appropriate course of action is to remit the matter back to the disciplining authority or the appellate authority with the discretion to pass appropriate order of penalty. The court by itself cannot mandate as to what should be the penalty in such a case. The only exception to the principle would be in those cases where the co-delinquent is awarded lesser punishment, even when the charges of misconduct was identical or the co-delinquent was first with more serious charges. And ultimately, my lord, the court held that this is the finding of the learned single judge as regards the punishment of the shockingly disproportionate. That is why I placed before that, my lord, in the reply, the other persons were dealing and they were not taking any action against them, my lord.
Counsel,
My lord.
why? Paragraph 40 of the impugned judgment,
Paragraph 19, my lord.
20.
20, my lord. Approval, my lord, is further the petitioner will receive the retirement benefits. My lord, it's true, my lord.
In the present case, the petitioner is found to be engaged in trade or business and collection of money without permission of the competent authority.
My lord.
The petitioner has also been found to have created vendor codes without approval of the competent authority for personal gain and manipulated the PAN number of one Shri Rajit Sharma. It is settled that the disciplinary is the sole judge of the facts and there is nothing to show of any inquiry officer are wholly perverse or illegally untenable. Further, the petitioner will be able to receive retirement as
applicable to
the petitioner being imposed with the penalties of removal imposed upon him. And so, on considering the above,
the court finds that is not disproportionate.
then how is
My lord, as regards the
you were engaged in some this what chit fund or whatever?
No, I was not engaged.
Banking or by a private institution, you were doing this in your workplace as well as home, and thereafter you have created some what these.
As regards these two charges, my lord, my reply was, it was not only me, the officers. It's true, my lord, because I want to.
Either you are challenging the finding of this disciplinary authority or.
My lord, because taking into account the learned single judge held when a co-delinquent is having the same offense and it was not taken care of, that shockingly disproportionate can be taken care of.
That was one of the instances.
My lord, my reply, and even in the inquiry report, the management witnesses say there was no persuasive or no kind of involvement on my part. They voluntarily came.
When you are working in an institution, and without the permission of that institution, you are doing some other business, side business.
Malad, it was not a
policy of that institution.
Malad, it was not a business on my part. Malad, I knew the procedure, and that is why I helped them in investing in that.
Or by collecting money from them.
Malad, it was their statement before the inquiry officer that they voluntarily came and said, please help us to invest in that place. That is their statement.
You are doing that for voluntarily. You are also doing it for no profit.
Malad, without profit, Malad. That is some statements are there, Malad. And that is why it was, Malad, no property was found against me. I didn't have any kind of property. Malad. And as regards the PAN cards and others, Malad, here it is not with me. I have replied that it is always with the officers. And
replied, me, sir, the witnesses have deposed against you.
Malad.
Sir, though we gave him money voluntarily, but he was involved in all these things. And that's why only the department has got a serious view about that.
Malad, and the department, Malad, here, as regards the other persons who have done it, the officers, they were not done, they were not taken care.
That example, sir, can't be. What is that?
Malad, I too, Malad, is a negative side. I cannot take care of the negative side of the particularly if some other persons has done something.
You are basically Not strictly, but you're arguing for discrimination that similarly situated persons were imposed less penalty, and I was.
No, they were not taken, no penalty, nothing was done, no disciplinary property.
Maybe, sir, one,
That is
that may
only
have
by prayer,
stated.
prayer before your lordship, but if certain.
Document was removed.
What remains the charge of abusing his official position by creating 25 vendor codes online without supporting document for personal gain and manipulating the PAN number of one Shri Rajiv Sharma.
Malad, this reply, it was a finding. Malad, where I have gone for an appeal also, Malad, where this finding I place it, Malad, is absolutely perverse to the, Malad, what I say, Malad, to the statements that I have made before that. Because, Malad, my statement was that over telephonic, there were some mistakes in the writing the phone numbers. And, Malad, the staff and the vendor codes, it is not with me. The authority is with the officers. That was my reply to the second charge. That it was lying with the officers. It doesn't lie with me. I don't have the authority to do it. That was my reply, and that was not taken care of by the inquiry officer. But your lordship may look into the second reply to my second charge, page 113. May I read it, Malak? Your lordship permits me. Reply to the charge sheet dated such and such.
Yes.
May I read it, Malak? Paragraph number 1, I have never abused my official position by creating vendor codes, and being only a B grade officer at that time, I had no extra power or discretion to take independent decision. Leave aside the question of ulterior motive or personal gain through favoritism. Please be informed the power to create vendor codes rested with all officers and employees who are having sub-user IDs. No special power for vendor codes creation were assigned to me. In such a situation, there are many vendors applying for registration creation of vendor codes through innumerable persons with recommendations senior officers. You may very well appreciate that due to crowding and urgency through scrutiny was not possible to order to speed up the entire exercise. And as regards creation, Malad, page 114, paragraph 4.
Yeah.
Malad, may I read it? Paragraph 4 in page 114. In case of hydraulic hand trolley identified as mechanical maintenance, the vendors who were based at a far off geographical location were deleted since the total amount was very low for single hand trolley. It was decided to send the inquiry to only vendors who are locally based or close by. Again, it is pertinent to mention that the vendors who have given the purchase order was in the original list forwarded by the mechanical maintenance. However, the file was processed through the prevailing procedure was duly approved by the competent authority. The technical acceptance was obtained from the user department in the mechanical maintenance, the inclusion of local vendors, and did not any manner harm or prejudice the interests of the corporate. And the inquiry report is at page 116. The findings are there, Malad, at page 119.
Yes.
Malad, moreover, the evidence, 119 page, Malad, I'm reading, paragraph 4.2.2. Moreover, the evidence put forward by management witness could not be, refuted by CSC during cross-examination. Though he was given an opportunity to produce evidence or witness in his defense, he did not produce any to nullify the approved facts. And the next paragraph, my lord, after the line, CSC Sri M.K. Vishwas abused the official position by creating vendor codes online SAP at his own discretion and also manipulating PAN numbers of vendors. During the defense, he had neither denied nor presented any evidence. He disproved the statement made and documents produced by the management group. These were the findings of the inquiry officers. Here, my lord, that is why only that my argument is limited scope. I know, my lord, taking into being, my lord. If this matter could have been once sent back to the authority to consider, my lord, that much, because without setting aside if they can consider my penalty, because in the service rule, my lord, it is, my lord, there are other punishment as such. 29, it states for withdrawal of increment, pay with cumulative effect, reduction in lower stages, recovery from pay, an amount of due and due to him of the whole or any of the pecuniary loss caused to the corporation, withholding of promotions, reduction in lower grade, compulsory retirement, removal from service, and dismissal. These were the many other penalties are there in the service code, my lord. My only submission to that extent is this, my lord, when other officers are there, it was discriminated on my against me, my lord. They have only taken care of me and they have put all the punishments to me, and that too at the harsh manner of removal of service, my lord. My lord.
Yes.
Ma'am,
You're for the other side.
I'm for the other side.
Yeah.
I draw your lordship's attention to paragraph 10 of the interim judgment, my lord. So far as the second charge is concerned, my lord, the only ground which was urged before the honorable single judge at page 174, my lord.
One seventy-four.
174, paragraph 10.
Yeah.
May I read, ma'am? The second charge sheet dated 24/2/2012 was to the effect that the petitioner had created 25 vendor codes online in SAP without supporting documents and approval of the competent authority for personal gain. He had also manipulated the PAN number of one so-and-so for creating vendor code for another firm in his name as so-and-so. The two charges in the second charge sheet dated so-and-so have been found to be proved against the petitioner. The last sentence, my lord. The only challenge to the above charges by the petitioner is that he made the vendor codes as the other officials in the IOCL did not know how to make them. So it is not his case that he did not make it, he was victimized, my lord.
Admitted it.
He admits that he had made it. The ground is that the other officers could not make it. A request was made to him, so he made it, my lord. In fact, in his defense also, he says that the power to create the vendor codes was given to all officers, my lord. In the very first paragraph, which my learned friend had read, page 113, my lord. And even in the inquiry report at page 118, my lord, if your lordship kindly makes a note, para 4.1.2 and 4.1.3.
What is this vendor code actually? What is it?
My lord, vendor codes, my lord, nowadays the payments are not made in checks, my lord. As a lawyer, my lord, I also have a vendor code. I have to submit certain details and the vendor code is created. The details of my bank account.
Vendor code. Who generates this?
The officers generate the vendor codes, my lord. Officer of the corporation. Concerned department.
So how it is helpful for
nowadays, my lord, I cannot say, my lord, why it is done, but nowadays, my lord, the payments are not released in check. Payment is directly remitted to the bank account. So whoever wants to do business has to create a vendor code where the PAN details and the bank details, everything is fed into the system, my lord. And
bank generates this vendor code and it's given to you.
No, my lord, the bank does not generate, my lord. Suppose I am a vendor, my lord. I want to do some business with the corporation.
Fine.
I have to give my details, my lord, like my bank details, PAN number, everything. Okay. Then the bank has to certify that yes, this information is correct. Okay. It is sent to the department and the officers will create the vendor code.
The officers will create the vendor code, right. And instead of directly or giving you a check or draft or whatever it may be, they'll get the money deposited in your bank account.
My lord, obliged.
So if petitioner has helped someone to create a vendor code, what is the problem with that?
No, my lord, he has manipulated the pen, my lord. That's why I was pointing out. Page 1.118, my lord. If I may kindly read, my lord. In the third sitting of the inquiry, Lordship has got it, my lord.
Page
118.
In the third sitting of the para number 4.
Yes, 4.1.2, my lord. In the third sitting of the inquiry, MW3 has stated and provided supporting documents to prove that Ms. Rekha Lal was the proprietor of one RS International, who had applied for vendor registration at Guwahati Refinery. Though the vendor registration was done under the name of RS International with vendor code so-and-so, the ownership of the firm had been recorded in the name of Rajiv Sharma. This is also corroborated by the fact that the original PAN number recorded against this vendor code in SAP was that of Rajiv Sharma and not of Mrs. Rekha Lal. Then Lordship comes to the next paragraph. In the fourth sitting of the inquiry, MW so-and-so has submitted a copy of his PAN card, which authenticates his PAN number so-and-so. During this sitting, it has been established that Rajiv Sharma is the owner of Raj Enterprise, who is the registered vendor of IOCL having code number so-and-so. However, as per SAP records, the initial entry of PAN number against this firm is so-and-so and not so-and-so, which is not the authentic. That is difference of a letter, my lord. So what he did, he took the original PAN number of Rajiv Sharma. He entered it while opening the vendor code of Raj International, and while opening the actual vendor code of Raj Sharma, he gave a different PAN number.
So let's take that it is a wrong PAN number given.
My lord.
So it'll hit a roadblock very soon.
It'll hit a roadblock, my lord.
So how does he stand to gain by that?
My lord, how he stands to gain, why did he create it? Without proper documentation, he has created it. That is the misconduct, my lord. Without verifying the documents, he has created the vendor code.
But correct, but you have to link it with some consequential benefit, no? Supposing somebody asks him, help him out, create a vendor code. He does it.
But he
while
may be caught
creating
at a
an
later
entry,
stage.
there is a
Lordship
wrong
is correct.
figure, wrong letter. That could be a wrong thing. But to assume the characteristics of a misconduct, and that is also of such grave nature, which could invite an order of removal, there has to be something more to it.
My lord, if your lordship reads further, my lord, he had dropped the names of certain vendors also, my lord, from the list of approved vendors. And 25 vendor codes without proper verification, my lord, maybe it will hit a roadblock. Lordship is correct. That if the wrong PAN is given, maybe after verification, it may hit a roadblock, my lord. But the act cannot be condoned, my lord. Had it been one instance that, yes, one mistake is there, my lord. 25 vendor codes without any proper verification, he has done it, my lord. And few witnesses have said that we did not even apply for creation of a vendor code. One vendor code has been created in the name of a casual laborer.
That's what we are asking you. So by doing this, what is the gain that he has got?
My lord,
is there any allegation to that?
No, there is no allegation as such that you have gained anything. In the charge sheet, there is no allegation that you have gained or you have taken money. But the act itself, my lord, in my respectful submission,
Continue after that.
may please, your lordship. Before answering your lordship's query, my lord, I'd just like to point out, my lord, at page 118, my lord. In addition to that, what he had done, because my lord, the lordship's query is that what he seeks to gain, my lord.
Mr. Roy Chaudhary has begun his argument in a different track. He has accepted that charges are proved and only the proportionality of punishment is what he has urged. But since this is the last court for the state, we wanted to know actually what is the real nature of misconduct, under which provision of the rule it becomes a misconduct, and what has he actually done. So if you could throw some light on that, that's all.
So for that, I take your lordships to the charge sheet itself, my lord.
Charge sheet itself.
Charge sheet. Lordship is considering the second charge sheet or both, my lord?
You have punished them on the basis of the second charge sheet or first?
Both, my lord. Both.
Both.
Okay.
Okay, first charge sheet.
First charge sheet, lordship finds it at page 24, my lord. Sorry, my lord, 59, my lord.
59.
24 is the page of the reputation. 17/6/2011.
Yes. Read.
That in November 2010, you collected a sum of rupees so-and-so from IOCL vendor so-and-so, proprietor of so-and-so, for investment in a non-banking financial company with assured return of rupees 10% so-and-so by applying pressure in your capacity as SMTO. SMTO would be my lord, senior manager. That between October to December 2010, you collected money from say so-and-so, 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 so-and-so in your quarter, 4 lines from the bottom. In your quarter number 2379, sector 2 township for investment in a non-banking financial company with assured return and so, and that you are in possession of assets disproportionate to the known source of income. This has not been proved, madam.
This has not been proved.
This has not been proved.
And this charges number A and B.
A and B. So madam, it is admitted that he has collected money. So the charges, under the clauses, the lordship will find at in the next paragraph. By committing the above acts, you have allegedly committed acts of misconduct as per 715 for collection of money within the premises of the corporation without permission of competent authority. 721, engaging in any trade and business without taking permission of competent authority. 73, for possession of pecuniary resources or property disproportionate to your known source of income, which cannot be satisfactorily accounted for. And rule 730 for commission of acts subversive of discipline or good behavior. So these are the clauses under which he has been charged, madam. Number 1, collecting money. Number 2, engaging.
So has anybody complained that he has?
Yes.
Who has complained?
That is not discernible, madam, from the charge sheet. But ultimately, it is admitted, madam, that he had done the business.
No, that there was a complaint. Must be some complaint. Then only initial inquiry was initiated against him.
The records do not reveal, madam, any preliminary inquiry being made. But ultimately, it has come, madam, that he was collecting them.
Okay, this is the first charge.
Madam.
And the second charge is?
Second charge sheet, lordship finds it at page 109, madam.
109.
Lordship has got it. It is alleged that while working as SMTO,
ऐसा लगाया सबने, मुनाफा नहीं मिला तो फंड नहीं मिला तो
And some FIR was also lodged.
FIR was lodged when there was a criminal case that resulted in closure, my lord. That resulted in final report. That lordship finds at page 75.
75, final report. And they accept
The finding? What finding?
It was regarding disproportionate assets, my lord. It was closed.
No. Here you just page 61.
61, my lord. That's the complaint, my lord.
That's page 61 of the paper book.
My lord.
List of documents by which the articular charge proposed to be sustained.
My lord.
Now this item number 3.
Yes, my lord.
Serial number 3, copy of the FIR filed by so-and-so, so-and-so, so-and-so. And all so-and-so against your collection of money, investment of so-and-so and failure to refund their money. What happened in this FIR? In fact, initially
This lordship turns to page 70.
Complaint.
72.
FIR.
Page 72.
72.
Madam.
72 is the type copy.
Yes.
My lord, first paragraph, investigation has thus revealed that the quantum of DA of the accused public servant is such and such. In comparison to the total income accused, the quantum of DA is very less, which comes to such and such. And it may not be right to hold that the assets found in the possession of the accused were disproportionate to his known source of income.
So that might be in relation to disproportionate of case.
No.
But here they are referring to one FIR 12/5/2011 filed by Sri Duro Deka, Binoy Kalita,
My lord.
and all these persons, wherein they have complained that this person has, or maybe we are not aware of what is the complaint, that he insisted us to invest the money and with the assured investment, but failure to refund their money.
My lord.
Way of misappropriation or 420 or whatever it may be. What happened to that FIR?
My lord, that FIR, my lord, it is ultimately submitted into a final report, what I find, my lord. And at page 74, page 74 is the court's order, my lord. Page 74 is the court's order, my lord.
Just a minute, Mr. Deka, can you please come to page 61?
Yes.
You see, this is a list of documents. In item number 3, it refers to copy of FIR dated 12/5/2011. But there is no mention of any police case being registered.
No.
But in the next item, it is again the same letter date. And here there is a reference to a Nulmati police case.
No.
So can you please clarify whether this FIR dated 12/5/2011 is the same as letter dated 12/5?
I'll have to check the records of the DP if it is there, my lord.
Please confirm us
My lord.
whether this is a separate FIR, this is the very same FIR.
That I'll have to come back to your lordship, my lord, because from the records I cannot say that. No.
Because you have relied upon the documents in the
Yes,
inquiry.
yes, I follow.
What are those documents? This is the letter dated 12/5. Either it's a date is the letter of this wrong mentioning of date, or FIR date is different. Maybe it is the same because 420/406. Each other.
Read with 456.
These expenses. This related to the three. This proportion is not the meaning. So many times is not a video was thinking and reading that
And what is the inquiry report?
First inquiry
My lord, the first inquiry report
is at page 90. Page 90 about the first charge.
First inquiry report is at page 90, my lord.
First inquiry report is
Page 90, 90.
90. Ultimately, this is the description of the proceedings. Then what is the finding?
Finding starts at 96, my lord.
96.
Regarding disproportionate, page 97.
Where is the description?
As a collection of money within the, without permission.
Maybe a minute, but
For the evidence part, Lordship may turn to page 91. One of the witnesses' evidence is discussed from 91.
only this, it was reproduced, sir. Not discussed. It is reproduced.
Yes, my lord, whatever the witnesses stated, my lord, he has reproduced.
Then how is that the inquiry officer has dealt with that evidence? What is the conclusion, sir?
Conclusion, my lord, at page 96, my lord.
96 conclusion.
My lord, from the account of WT1, WT2, and WT3, it is proved that he collected money from them in the office for the purpose of investment in the Unipay scheme. He had been collecting money from investors at his residence too. This lordship will relate to page 91 and 92, my lord. '91 in a table format, my lord. Point number 2. What the witnesses have deposed, my lord. Then if we read further, my lord, page 96, WT4, WT6, and WT11 have clearly stated that they had visited the residence of the CSE and made payments for investment at his official residence. WT17 and 13 have submitted bank statements which show that money was paid to CSE for investment purposes. WT6 and 12 have shown SMSs received by them from so-and-so, which indicate that the payments were received through CSE. CSE has also submitted document to prove that he had made payment to Mrs. Unipay from his bank account. He has collected money from various interested investors in his bank account as well.
Various investors.
Various investors, other investors. The bank transactions for rupees so-and-so, so-and-so, so-and-so are all related to investments of Unipay, Exhibit 15. The CSE had collected money in cash as well as in the form of check in his office and in his residence without the required permission from competent.
What is Unipay? Is it
that gold scheme, my lord?
Oh.
I am also a victim of that.
The multi-level chain system.
It was a chain system, my lord.
Remember getting members.
It was a chain system, my lord, creating downlines, my lord. You invest someone under you, for that investment, you get some returns and that, so on and so forth.
And what about the other charge?
My lord, second charge. Second charge sheet, lordship finds at page 109.
So if it is a business for the petitioner, the same thing applies for other investors. Why have you not proceeded against them? They have also
They
paid
were
money.
investors, my lord. He was the one who was bringing them in. It is something, it is.
They are also going in to get some benefit.
Yes, because he had advocated that he please come in the business.
Yes.
Page 109, madam.
Yes.
It is alleged that while working as SMGO during the period from so-and-so, you committed the following acts of omission and commission. You abused your official position by creating 25 vendor codes online in SAP at your own discretion without supporting documents and approval of competent authority with ulterior motive for your personal gain. RFQ for quotation for various items were sent to the following 7 vendors whose vendor creation details are not available. Out of the 7 vendors above, 2 vendors, that is so and so were awarded purchase orders. So, my lord, this will answer your lordship's query, my lord. This is the gain, my lord. When you create a vendor code, he will, even though he is not entitled to be a vendor, my lord, he may get orders because some orders are given on nomination basis, my lord. So the petitioner, the appellant, my lord, he seeks to gain indirectly. So now, number 2, you manipulated PAN number. This I have already read, my lord. You manipulated the PAN number so and so of Rajiv Sharma, whose name of so and so, so and so, so and so. Then again, same allegations. Then for lastly, my lord, at page 110, my lord, for procurement of hydraulic hand trolley, file number so and so, you dropped 5 vendors. The names are given. Recommended by the interior mechanical maintenance and included 500 vendors, that is so and so, so and so, as per your choice. Among these, vendor codes of so and so were created by you without any credential. So by acting, the clauses are 7.5 and 7.30. With utmost humility, he does not allege that he was not given adequate opportunity to present his case. In fact, now
That is not his case.
That is not his case. The case now sought to be projected that a similarly situated person, namely the witness number 3, my lord, in the first inquiry, he was an investor, my lord, some lingo.
He's the officer.
He is an officer. He, my lord, the delinquent, my lord, adduces no evidence against that particular person. It is only a statement in his written statement that he also was interested.
Otherwise, no other evidence.
There is no other evidence before the inquiry officer.
So he was exonerated.
No, there was no inquiry against him.
No inquiry.
There was no inquiry against him. So his case that there was an inquiry, that judgment relied upon by my learned friend, which the alternate single judge is distinguished, my lord. That was our case where similarly situated person, one was awarded a lesser punishment and one was given a higher punishment. Here it is not the case.
How many years had he completed in service?
Joined in. I was removed from service on 9/1/2013, and I joined service, my lord, 2003.
10 years.
10 years.
10 years. But when removal is imposed, my lord, he'll get certain benefits. If your lordship sees the Honorable Single Judge has quoted clause 29 where the punishments are prescribed.
Yes.
The ultimate is dismissal, my lord. At page 178. Starts at 177. (178), my lord. 13 is dismissal and 12 is removal. And lordship has already read, my lord, at page 20, I mean paragraph 20. Honorable Single Judge has dealt with that by imposing the punishment of removal, he'll be entitled to certain retirement benefits. In my respectful submission, my lord, it is not a punishment which is grossly disproportionate to the offenseman.
He was removed in 2013.
He was removed in 2013.
Around 11 years back.
My lord, only one submission if I can make, my lord. As regards the other statement that the officers who were not the investors, they were also doing their business in the company, but nothing has been taken there. No inquiry was there. In my written statement, I have said, those officers were also involved in this business.
That was not a defense even.
Well, in the written statement, I have stated, my lord. In my written statement, I have stated, my lord. The first reply at page 86, my lord. Page 87, my lord.
These witnesses are the employees of the corporation.
Some are witnesses, some are outsiders, madam.
Who invested as per his insistence.
Yes, yes. There are certain vendors also, madam.
Vendors is altogether different.
No, my lord, he was in the position where he was taking supplies, my lord. He was in the materials department, which is responsible for making purchases. So that is also an allegation that you have influenced these persons to make investments under you.
My lord, page 91, the statement of the witnesses. This was also accepted by, however, all these witnesses have clarified
96 is a list of witnesses.
that there was no any pressure from CAC to make investment. There was a statement from the witnesses. There was
the
no,
witness.
my lord, witnesses number 1 to W2T1 to WT7, page 91. There was no pressure from the CAC.
May I just point out one thing? Page 96 is the list of witnesses.
Yeah.
And my learned friend has just now read that few witnesses says that he had not lured, my lord. 93, page 93, the particular witness says, my lord, WT10 has expressed that CAC co-public lured her to make the investment in the scheme. The witness expressed that the CAC often used to advocate about this scheme in the office and had enticed many of the investors. She made the payments in cash and CAC collected the same from her house.
Why? See, this lured is not, it's lured because the person thought that he or she will also get good return.
Yes.
When that didn't happen, then they said, all right.
Yes.
But why did they come into this scheme? Because they expected to make some money,
But
correct?
If I lure my friend here, to please make an investment, he makes an investment.
Yeah.
But he does not do anything further. He does not do his business. So he cannot be charged.
No. Mr. Dekha, that's why, my lord, the Honorable Chief Justice was also pointing out. See, these are in those days, there were many such schemes.
Yes.
Member get member, you get 4 member, he will get another 6, and then you put in 5,000, you get 2 lakhs, something like that. So everybody who comes in with the same idea of making money. That arguments, please don't make it. Somebody may be more active, somebody is a leader who will invite applications, push people, coax people, casual people, whatever. But everybody who pays in money does so because he or she wants to make some gain out of it. This is not a business. This is a member scheme.
It is a business matter.
Yes, absolutely.
Some of the investors are this IUCL employees also.
Two of them are.
No, around page 96.
My lord.
This witness number 1,
Yes.
2, 3, and this
10, my lord.
10.
10.
4 out of 14, 4 are the employees of the IUCL.
Yes.
So maybe he was one of the person who instigated. Suppose Mr. He asked you that it's a very good film. You go and please see it. You go and buy a ticket and you don't like it. So he's luring you and you can complain कि सब मेरा पैसा लग गया टिकट का इतनी बेकार picture दिखा.
Absolutely. This is not a business. If that is, if this scheme was barred under the law and he promoted it, straight away it's a case of misconduct.
But he was collecting money, man.
Collect, he will collect. Where will he collect?
No,
He will
collecting money is barred under the rules, man. Collecting money itself is barred under the rules.
Collecting means, what is the meaning of collecting?
Collecting means, man, whatever, for whatever reasons. If your lordship reads the charge sheet, my lord. Clause 715 of the CTA rules, my lord.
15 and 20. Where is that?
My lord, 715, my lord.
7 connection without.
I have a copy of the CTA rules, my lord. I have, sorry, my lord, I have only one copy of the CTA rules. 7 subclause 15, my lord.
What about the second charge?
Of the second charge sheet, my lord. That is, in my respect, to submission even graver than the first one. Because it's a case of creating vendor codes, as I have demonstrated, my lord. He may not be a direct beneficiary, but he creates a vendor code in respect of someone who is not entitled, my lord. Then on the basis of that, he gets a job. So obviously, my lord, we cannot fill up each and every gap.
Is it a fraudulent transaction?
It is, my lord.
Have you lodged any complaint?
We have not lodged any FIR.
Why is that?
Because, my lord,
you know that your employee is committing fraud, but you look the other way. Why?
we have decided to proceed departmentally, my lord. It is not that, my lord, the person does not exist. He made a verbal request. Without verifying the documents, he has done it. And as evident from the charge sheet, few of them had also got orders.
Mr. Counsel, what was your reply to this charge sheet? Second charge sheet.
Second charge sheet, my lord, reply is at page 113. My lord, sorry, my lord, my reply.
Yes, my lord, 113.
113. RFQ means request for quotation. RFQ means request for quotation.
Request of quotation from the persons who are engaged, who was engaged in some supplying some material.
Malad.
And you have verified Tulsi Kalita.
And allotted vendor code, but they had not given RFQ order. They have not given any request for quotation or order.
Based on the due to crowding of applicants and the urgency of the matter, vendor coding could not be thoroughly scrutinized, examined, and more so in the absence of clear-cut guidelines for the process. Now you are taking shelter of that. There is no clear-cut guideline.
No.
And due to crowding can't take a excuse of that.
Malad,
It is least expected that even though if the crowding is there, you have to scrutinize the application in a proper manner.
And page 114, your lordship will find in para 3. 114 para 3.
Yes.
Tulsi Kolita was allotted the vendor code based on application which was not filed properly and could not be retrieved. This was due to crowding of application, the initial.
Again, crowding.
Next line, however, the vendor such and such had not given the request for quotation. Therefore, the question of favoring unethically does not arise whatsoever. So they have not given for quotation. And the next one for hydraulic hand trolley, manuals who were based on at far off geographical location were deleted since the total amount was very low for single hand trolley. It was decided to send the inquiry to only vendors who are locally based or close by. Again, it is pertinent to mention the vendor who has given the purchase order was in the original list. However, by the mechanical maintenance, however, the file was processed through the prevailing procedure and was duly approved by competent authority. The technical acceptance was obtained from the other department, mechanical maintenance. Inclusion of local vendors did not any manner harm or prejudice the interest of the corporation.
Pick and choose. You picked one vendor and placed the order to him without inviting application from the other persons.
This is for hydraulic, but this is only because it was a small one and it is the persons who are at distance.
But ultimately, small one or
and the persons nearby.
you have to follow the procedure.
Malad.
You can't
But
that procedure.
in the charge sheet, they have stated, Malad, that I have made some fraudulent PAN cards and others.
एक बार सोचा कि जिससे क्या तो खाली फर्स्ट क्लास में होता तो उससे सेकंड वाले
Yes.
Only thing hurt because he is without job and without anything, Malad. If some consideration, Malad, sending back to the authority to consider his case.
We will consider, let us see.
But he's not in a. Ultimately, he gained nothing out of all this, Malad. He is.
I've handed over a copy of the CDA rules, my lord.
Yeah.
Obliged.
Item 19.
Yes.
Yes.
May I please the lordship? Lordship,
Here, Lordship, after filing this writ appeal, affidavit on opposition has been filed and everything is admitted. Thereafter, Lordship, that whatever Zirat compensation amount, that is released, Lordship. Release, Lordship. After deductions of TDS. So, Lordship kindly peruse the order dated 8/11/2023. Lordship, the TDS liability is not applicable in this present appellant, Lordship.
My heckling counsel have drawn attention to section 90 of right to pay compensation. No income tax is stamp duty shall be levied on the work. Section, but no person claiming that the part taking shall be liable to pay. Did not be disputed. Section does not fall under section 46 of the. The authorities concerned are required to consider the aspect of facing new compensation. Yes, what happened, ma'am?
Yes, Your Lordship. After order dated 8/11/2023, Your Lordship, when the matter was listed, on that occasion, Your Lordship, I had placed the instructions received from the Deputy Commissioner's office. This is a communication addressed to me dated 27 December 2023. If Lordships have found that. 27/12/2023. Lordship has found?
Yes.
Yes, may I read, Your Lordship? Yes, Your Lordship. With the reference to the subject cited above, I would like to submit herewith the details for deduction of TDS towards the compensation amount against acquired land under LA case number such and such, award number such and such for construction of composite check gate at Sagolia as follows. The LA proceedings was initiated for acquisition of patta land measuring such and such as per the Land Acquisition Act 1894 under LA case number such and such for construction of the composite check gate at Sagolia under Dhubri district. After completion of the required formalities as per the LA Act 1894, the LA estimate amounting to rupees 6,15,83,297 for land and zirat falling in the alignment was prepared as per the said act and accordingly approved by the government of Assam Revenue LR Department, wide letter such and such, copies enclosed annexure 1. The TDS amount has been deducted towards the compensation amount for land acquisition purpose as per the government of Assam Revenue and DM LR Department dated 30/4/2011, annexure number 3. Now, Your Lordship, if would kindly come to the annexure number 2. This is from the Deputy Secretary to the Government of Assam Revenue Department. Your Lordship, yes. Applicability of income tax towards compensation received by the landowners for the land acquired under the Land Acquisition Act and other rehabilitation grants as well. So, with reference to the subject cited above, I am directed to forward herewith a photocopy of the circular under reference received from the Director Land Reforms, Government of India, Ministry of Rural Development, Department of Land Resources, New Delhi, which will speak for itself, and to request you to kindly take necessary action accordingly. The subsequent page, Your Lordship. Subsequent page. This is, Your Lordship, the circular dated 13th of April 2011. Now, Your Lordship, I am directed to say that the government is giving special attention to the issue of people getting displaced on account of development projects and therefore has been contemplating to amend the Land Acquisition Act 1894 and also bring up rehabilitation and resettlement statute. However, it has been brought to the notice that the people who are getting compensation are getting charged towards income tax and TDS of 10.3% is being deducted from the source. It appears that LA collectors are often not fully aware of details of taxation laws and erroneously subject landowners who have their lands. Yes.
Initially, you filed the writ petition for compensation.
Yes.
And during the pendency of this LPA, it was given to you.
Yes, Your Lordship.
Only the question regarding this TDA,
TDS.
that was not in the writ petition.
Lordship, at that time, Lordship,
At that time, compensation was not even
not
paid,
paid,
so there
so-
is no question of
No, yes, Lordship.
this TDS.
Yes, Lordship.
So now, if you are aggrieved by this, it's a separate cause of action. You may take your liberty to challenge that action of the respondents of
Lordship.
No, Your
It's a separate, because now here, though they have produced some documents, whether, how can we examine without there being any proper pleading about that?
Yes, Lordship. But that documents is not supplied to me, Lordship. That's
Lordship, I'll hand over a copy, Your Lordship. On last occasion, it was
okay,
partly
But
held,
ultimately,
heard, Your Lordship.
ultimately, the question, because no pleadings in this respect, only originally you filed the
Yes.
petition seeking some compensation, give us the
Yes.
compensation.
Yes.
Now the compensation is paid, now another question crops up. That whether they can, they deduct the TDS or not. That is a separate question you may
yes,
agitate it before the.
Lordship. My humble submissions, Lordship.
Yeah, we'll grant you the liberty.
Yes.
In appropriate proceedings, you can challenge that action of the respondents.
Lordship, I am not challenging the TDS part, Lordship. I am saying, Lordship, the law is itself given a bar. There is no tax liability.
Now they have produced some circulars on the basis of it. They are asking that we are justified in deducting the TDS.
Yes.
Whether that is, they are justified or not, that is to be seen and that is to be adjudicated in appropriate proceedings, not in these proceedings.
Lordship, Lordship, my humble submissions, Lordship.
Yeah.
When law is itself given a bar, Lordship,
So
then
that is, in fact, yes, we can understand you may have some force in your contention. But here the question is that before the learned single judge, there was no pleading of this effect, neither their counter on their behalf. How we can go into randomly or go through it, they can do it or they can't do it.
Lordship.
So proper proceedings, you may initiate the proper proceedings.
Lordship, if possible, Lordship, can we file an additional affidavit, Lordship?
So then you have to amend the pleadings, whole pleadings, because now the tenor of the writ petition is altogether changed.
Oh.
So altogether, the nature
Yes,
of the
Lordship.
petition is altogether.
Lordship, observe one. Lordship.
Yeah, we'll grant you the liberty.
Yes, Lordship. And Lordship, along with Lordship, another point is there, as because Lordship, after more than 10 years, amount has been given, released. So there is part also, Lordship, the interest part,
10 years, then
more than 10 years.
so you might have got this.
Yes,
As
Lord.
per the Land Acquisition Act, you got the compensation. Na?
May I?
Lordship, I am saying, Lordship, that whatever interest part, Lordship, my amount, whatever.
Part of,
May I, Your Lordship, regarding the delay part, Your Lordship, the affidavit has been filed. Your Lordship, page 60, paragraph 8. There it is clearly stated, Your Lordship, where the steps were taken to issue notice to the landowners for handing over possession over the acquired land in December 2008. Yes, but due to interim order of the Honorable Guwahati High Court dated 6/2/2009 in Writ Petition 74 of 2009, the process was kept in abeyance. Subsequently, on final disposal of the said writ appeal by the Honorable High Court wide order dated 3/12/2011, the process was reinitiated after compliance of the order direction as per the Honorable High Court. Accordingly, the date was fixed for taking over possession of the acquired land with effect 18/2/2013, and notices were handed over. Possession of the land were issued. While the process was taking over of acquisition of land, another writ appeal was filed by the legal heirs of the writ petitioner as numbered as WPC number 74/2009 wide as WPC number 791 of 2013, Safar Ali and others versus State of Assam. The Honorable High Court passed interim order dated 22/2/2013 in the above noted case to maintain status quo in the respect of the land of the writ petitioners.
The said writ appeal was vacated by the Honorable High Court by final order dated 2/4/2013. It is worthwhile to submit here that the subject matter of the instant writ appeal is almost similar and identical to the other two earlier writ appeals stated above, and the Honorable High Court was pleased to dismiss both the writ petitions. Subsequently, on final disposal of the writ petitions as stated above, the process of taking over the land and has since been completed and handed over to the representative of the requiring department, and the payment of compensation and process of the payment is underway after observing required formalities. The LA estimated fund provided by the requiring department was kept in the revenue deposit under head of accounts such and such. Despite of another writ appeal number 3046, this is the filing number 2013, Kamakha Karmakar versus State of Assam, the process of release of compensation money and Zirat value was kept in pending. As per order of the Honorable High Court dated 1/11/2018, the payment of the process of the required land and Zirat are under. There were multiple litigations, Your Lordship. That's why the process took time. That's why the delay incurred, Your Lordship. And also the possession was not acquired by the authorities, Your Lordship, because the payment was not made.
What was it there in the writ petition?
Lordship. Lordship, case 23, Lordship.
Case 23.
Yes, Lordship.
This amount has been paid, Your Lordship.
Yes, sir.
So their prayer is for payment of 14
14,
lakhs,
yes.
57,000
Yes,
something.
yes.
And they have been paid 6
Yes.
crores, 15 lakhs something.
No, Your Lordship, Lordship would kindly come to the documents dated 2/11/2023. This is by the Dhubri District Administration, Your Lordship, 2/11/2023.
Along with these documents now you submitted this.
Yes, on the prior date of hearing,
Prior date annexure.
dated 2/11/2023, Your Lordship.
Have you marked it as annexure?
Your Lordship, I couldn't make it as an annexure. It was handed over in due course of the hearing. 2/11/2023, Your Lordship. I'm sorry, Your Lordship, it was. Lorships, can I? Another bunch, Your Lordship, not this bunch, another.
Another.
Yes. 2/11,
2/11, yeah.
Yes, Your Lordship.
Special messenger.
May I read it, Your Lordship?
So paid amount of rupees 14 lakhs 57,124.
Yes, Your Lordship. Well, the last page also, Lordship may kindly peruse.
Yeah, last page.
Last page, Your Lordship. It is from the treasury. It is from the additional DC to the treasury officer.
Okay.
1457124. The amount has been released, Your Lordship.
We ordered it.
And then the TDS got deducted.
Thus the authorities concerned are required to reconsider the. The primary giver doesn't redress.
Also, your lordship, if they, it's a tedious matter, your lordship, if they pay the tax returns, your lordship, they are liable for the refund of that 10%.
Lordship, this is another aspect as per my instructions, Lordship, the present appellant is not getting that TDS back because TDS return, Lordship, TDS, there is a procedure to get back the TDS amount. Lordship, but Lordship here, as per my instructions.
Just a minute, you please, listen the order. The present appeal is filed by the appellant being agreed with the order dated 25/10/2021, passed by the learned single judge as writ petition number 4638/2021, whereby the writ petition filed by the petitioner has been dismissed. Full stop. In the writ petition, the main prayer of the petitioner, of the appellant, sorry. In the writ petition, the main prayer of the appellant was to issue a direction to the respondents to make payment of Zerat/household compensation of rupees 14,57,124 pursuant to the acquisition proceedings. Full stop. It is noticed that during the pendency of this appeal, the respondents have paid the amount of rupees 1457124 in lieu of compensation. However, now the petitioner is aggrieved with the action of the respondents of deducting the TDS on the said compensation amount. Having gone through the writ petition as well as the counter affidavit filed on behalf of the respondents before the learned single judge,
No,
we are of the view.
In this case.
before this bench, Lordship, not single just.
Acha, before this bench?
Yes, Lordship.
Yes.
No, they find the counter affidavit here.
Acha, not in the writ petition. Okay. Having gone through the writ petition filed by the appellant before the learned single judge, we find that initially the petitioner was aggrieved, the appellant was aggrieved with the action of the respondents of not paying the compensation amount. However, now when the compensation amount has already been paid to the appellant, of course, after deducting the TDS,
10%.
it would be
10%.
after continuing TDS at the rate applicable, it would be a separate cause of action, and the appellant is free to challenge the same by appropriate proceedings before the appropriate forum. Full stop. With this liberty to the appellant, this writ appeal is disposed of.
Lordship. Lordship, one observation maybe keep Lordship. Section 96, where absolute bar has been given.
That is, that amounts to going into the merits of the case, and at present we are not supposed to.
Lordship, he is referring to that section of 2013 Act.
Lordship,
But the the entire procedure was as per 1894 Act.
Lordship, that's.
So 1894 Act accordingly.
That was permissible.
Yes.
No, Lordship,
That is your argument, and he will make a counter to that, and appropriate proceedings in the appropriate will be adjudicated.
Lordship, one liberty, Lordship, one more. Lordship, another remaining part is their lordship, the interest, yes, because about 10 years back, lordship, lordship,
Already
lordship, if
pointed out
You are
what the
free to
delay.
raise all these in those appropriate proceedings. You ask for more things.
lordship, if an observation, if lordship.
No, your
What
lordship,
observations?
I've
Lordship,
already stated in the affidavit.
I will raise then that part, lordship, in this.
Lordship, the department was going to pay the money.
Ma'am, please.
Yes, your lordship.
Please.
Yes, your
There is no prayer for interest in your writ petition.
Yes.
So how can you orally make a prayer like this? All right.
I'm obliged, your lordship. I'm obliged.
Highly obliged, lordship.
Item 20 and 21.
May it please your lordship. This appeal is relating to appointment of LPG distributorship in rural area by the ISL authority.
I think about 20 coming.
Yes. Yes.
Your lordship, the judgment is that my lord page 276, my lord, but defects of the case, your lordship has gone through my lord, paragraph 3, page 279. Defects of the instant case is that so and so an advertisement was published in newspaper namely so and so by the ISL authority, Bharat Petroleum Corporation, Hindustan Petroleum Corporation, jointly for appointment of the LPG distributorship in different areas within the state of Assam. A perusal of the said advertisement, which was placed before this court during the hearing, shows that this said advertisement pertaining to 33 locations wherein applications were invited for appointment of distributorship. The present writ petition relates to the appointment of distributorship in the location Jamlai village, Kalyanpur under.
Who has filed the writ petition?
I have filed a writ petition, my lord.
You got to.
Set aside and quashed, my lord. Impugned order set aside and quashed. But my lord, only in paragraph under equal lordship, go to the last, my lord, that first, it is in page 295, my lord.
The para number, relevant para of the judgment,
Paragraph number?
relevant para of the judgment, of
Yes,
the
sir.
improved judgment.
Yes, yes. ma'am.
Which judgment, you are
Which
agreeing
para?
by
Which
which?
para? That is set aside, my lord, that impugned order was set aside, and my lord, but I'm agreed by the paragraph 26, my lord.
26, the
Yes,
learned
ma'am.
counsel for this.
Agreed by, yes, my lord.
Yeah,
That's from page 25, I'm reading, my lord. Selection of LPG distributors will be done through laws and eligible applicants for that location. It appears, that is the relevant line.
Yeah.
Page 295, that it appears from the records that apart from the petitioner and the respondent number 4, there were 12 other eligible applicants. Under such circumstances, the question of issuing a direction to the respondent ISL authorities to issue a letter of intent and letter of appointment to the petitioner do not arise. Further to that, it is also relevant to take note that the other applicants are not parties to the instant writ petition, and as such direction would be contrary to the constitutional norms. I'm agreed by this particular line, my lord, because I'm the only.
can you be that?
My
When
lord,
there are
let
more
me
than-
submit.
more than
Fancier
two
cannot be invited, my lord, that fancier.
When there are more than two applicants.
Yes, my lord.
If there were two
But my lord,
applicants, then we would
no,
have
my lord,
understood
they were not
one was
selected.
not eligible.
They
so
were,
only
they were not fulfilling the criteria. That
Which
is the
one?
point. Other applicants, my lord, they did not fulfill the criteria.
where is the
They
finding?
don't belong to that particular place. Like my lord him.
Their applications were rejected.
I
their
don't know about that.
applications
I
by
don't
the-
know about that because my lord, they hold a press, it's a system of
How
lottery.
many persons have applied for that distributorship?
I think 12 or
For a
14.
particular location,
The
how many
ISL
persons have applied for that?
That my lord, records will be having by the ISL authority, my lord. How many persons have applied, that I don't know, my lord.
You don't know. The learned single judges, the petitioner,
If there's a
apart from
list
the
of ballot,
respondent
page
number 4 and
14, my
12
lord,
other
yeah,
eligible
14.
applicants.
Place 55, my lord. Place 50. Place 55.
There are more than one applicant or more than two applicants were there for
Yes.
the single
But
distributorship.
do not fulfill the criteria.
So that is whether the IOCL or the distribution
Yes.
company has examined that or not. They have not rejected their candidature.
Because lottery was held and it was selected, my lord. No question of rejection, my lord. The procedure they are
Essentially,
following.
you have challenged the selection of respondent number 4 as the distributor or
Yes,
letter of issuance of
yes,
this letter
yes,
of
my lord,
intent to him or her.
He is not a resident of that area.
From and the court has given a finding, yes, his selection was bad.
Yes, ma'am.
But then in that event, the court is required to direct them to initiate new process or at least the eligible candidates, other candidates are there. Draw a lottery for selection of the.
My lord, that
You can't say as a simply because
he is
you
the
have challenged
person
the.
agreed, my lord, as per his knowledge, he is the person, the petitioner is the sole person belonging from that village area. So, my lord,
Maybe,
that's
sir,
why he has.
whether their applications were rejected, apart from respondent number 4,
Amounts
whose
were rejected.
application has wrongly been accepted, other applications were also rejected on
After
the ground that they are not the residents of that area.
That I know, my lord, they are not residents of area, and my lord, that not,
That
they are
I
not
know, then
fulfilling
they'll
the
consider
condition.
it. They'll
My lord,
consider it.
ISL authority will submit, my lord, how many were of
Yes,
them were
you,
eligible.
IOCL, it is for the IOCL. Yes, you
Yes,
got a
I am
penny
to
for the
reply, my
IOCL.
lord. Yes.
Yeah.
After the learned single judges direction, we have acted upon, we have compared with it and we have cancelled the candidature of the parent. And thereafter,
Yeah, respondent number 4, you have cancelled that. Yeah.
thereafter we'll be proceeding as per the guidelines which mandates that we will be putting a draw, including balance price.
That's right. How many persons have applied for that?
Now, the 14 persons were there, since one of
13 remains. And what they are saying is that all other these candidates are ineligible.
One of the
Yes,
procedure is
somebody
when
will
you file
submit
the
it.
application online, you submit your credentials.
Yeah.
Once in the draw of one particular applicant is selected, then we go for the field verification. process.
Verification, yeah.
Only then we find out who is eligible and who is not. Just like the private respondent candidature has now been cancelled by the Supreme Court. Madam's stand will also be considered along the remaining 13 candidates. If he comes out successful, we'll go for the field verification and we'll find out.
Now his candidature can at all be considered.
Madam's stand.
No, this respondent number 4.
We have already cancelled the candidate.
Because you are not seated by the learned single judge on the ground that you are not the resident of that area. That pending you are challenged.
But Lordship, therefore we prefer an appeal.
Appeal is
Because
there.
I am also not permanent resident, but temporarily I am tenant. The document also enclosed that there is no any finding and regarding my tenancy agreement, my lord. So far, my lord, advertisement is concerned, the person should be a resident, not permanent resident. There is no such clause.
And the
And therefore I challenge because I am being
the
resided.
tenant covers under the definition of this resident.
But yes,
Tenant
lordship,
covers under that.
yes, I'm resident, lordship.
Just show us which is which.
I am also
provision is in
resident
your
in
favor.
particular area since long back. I have narrated,
Maybe.
and so far, my lord,
Whether this advertisement defines about the residents. Is
only
there any-
advertisement saying that resident, particular resident.
They must have clarified it.
Advertisement show, advertisement.
They must have.
Guidelines say.
Huh?
The guidelines, the advertisement is based on the guidelines. The guidelines say that you are required to be a citizen of India and a resident of the locality.
Resident of the.
Now, as per the priority list, the first list is comprises of the person from that particular gram panchayat. As per the advertisement. So there is 14% come into play. Now, he became a tenant of that particular place on 4th of July. The last date was 15th of July.
Few days before.
That's a vacant land. In the judgment, it is mentioned vacant land.
About a month ago.
About?
Advertisement was also floated about a month ago since he became a tenant.
No, that is
Tenant of a vacant land.
for construction of the
Started
godown.
residing in that locality 1 month before the advertisement.
So we carried out the field verification.
And you found that he is
We
not
found
the.
that he has been standing there since 4th when the last date was 15th. We considered it. Then the single judge has now said that based on the Supreme Court judgment, that if you, the definition of resident, so even if it is not particularly specified whether it's temporary or permanent, if we consider the permanent.
It should be considered as a permanent resident. Well, that what remains, sir. The finding given by the learned single judge based upon the Supreme Court judgment, what remains then?
But that judgment not saying that that tenant is not entitled to.
Residence means permanent resident, what they are saying, subject to their confirmation.
He
what it means in your sentence, sir?
Permanently reside or temporary reside. That is also termed as resident.
What he's saying, the Supreme Court has defined that residence, if it is not defined, then resident means permanent resident. This is what he's saying, or he is incorrect, then you show us.
And so far, my lord, my appeal is concerned.
Yes.
And here, my lord, I have enclosed tenancy agreement, and in item number 20 also, the tenancy agreement, my lord, page 237. And there is no any note on this point, my lord, and no any objection raised from either of the side. That I was residing here, the particular locality, my lord, since my lord 8/7/2017, a long period. And when person residing in a particular area, in a long period.
2017.
Yes, lordship.
And the advertisement was issued on which date? 2017 and advertisement was of 2018. How can we treat you as a permanent resident of that area?
But I am not claiming that permanent resident.
Or even
But
though
I
resident of
was
that
a
area.
resident. of the
Ordinarily,
locality.
ordinarily a resident of that area. How can?
And so far, my lord, the appellant, my lord, in item number 20, my lord. Lordship. The item number 20, my lord, the appellant cannot be an aggrieved party because, my lord, so far cancellation order, when he found anomalies and therefore his selection was cancelled. And that cancellation order, my lord, page 138, has not been challenged in the writ petition. Now, writ petitioner in item number 20, my lord. Who is the writ petitioner?
In fact,
In the writ petition,
her candidature was not rejected. Her candidature was rejected.
Rejected, lordship.
Not
No,
rejected
no.
and no communication.
Candidature was rejected, first selection was rejected. He was not appointed. But initially he was selected in the first draw. But when the complaint raised from different corner, then this order was passed by lord, page 138 in item number 20. 138. Yes, because he applied a dual petition having double name, my lord. And therefore, this, my lord, order that at 2010-2018, page 138 in item number 20, my lord. And this
138, yes.
Yes. And this was cancellation order acknowledged to
As per
adjust
the
to
names of the applicants, only
Royal
once
Sundar
the
Park.
time of draw, hence your selection is about draw. Single
And received on 24/10/2018.
We like to mention here that your name is application serial number candidate so and so. Candidate same serial number 4. And because you have changed the spelling of
And this order has not been challenged in either of the two writ petition.
If she has not challenged that order, then she is happy with it.
No,
What
no,
to do
lordship,
with?
thereafter, my lord, he had participated in the second selection process. That is page, my lord, 64. She had participated in second draw.
So,
and thereafter, my lord, how he can agree when I am being selected in the lucky draw?
maybe you are selected because you are not the resident of area, resident of that area, and that's why only you are not suited by the learned single judge. That's all. So far as regarding this item number 19 is concerned, now 20 is concerned, ma'am, your challenge is nothing. You have already got the relief. And the single judge has kept it open for them to consider all the applications and draw lots.
No, my lord.
Then only it's
As
okay.
per law, my lord, I will submit, I will try to satisfy your lordship, my lord. Number one, my lord, initially in the first draw, I was selected. Thereafter, without any communication, without giving any notice to me, my lord, they draw the second draw, my lord. And my lord, the clause they have shown or they have filed in the affidavit, that is there in the judgment, if your lordship has quoted, my lord, paragraph 3 itself, my lord. In the judgment, what are the clause for rejection of my candidature? That is, my lord, as page 280, my lord. Because I filed two applications. Page 280, paragraph 5. And so, for one application per applicant for a location. Applicants should submit only one application for one location. In case more than one application is received from an individual, all the applications would be clubbed together and treated as one application. In such cases, application fees received against all other applicants would be forfeited. That's fine. But my lord, in the affidavit, they have showing the ground, my lord, their affidavit in opposition, my lord, is 126. I'm reading from page 127, my lord. Paragraph 4 is 127. Is 127, paragraph 4. Then in the last line, my lord, in case more than one application is received from an airplane, all the applications will be clubbed together and treated and so and so, so and so. As the scrutiny of applications was done online, the online system could not detect the submission of two numbers of applications by the same applicant. So and so mentioned his father's name and title differently in both application number and father's name has been started, then so and so, so and so. So, my lord, that is the reason, my lord, my application. The writ petition, the deponent wishes to set that petitioner was selected for the first job lots, which was held on so and so, on which Sri Dalsan Paul was declared as the selected candidate for the location Jamla, and after his selection, certain verbal complaints were raised by the other applicants who were present on the date of draw, stating that the petitioner has applied twice and as such his candidature should be cancelled. Later on, a formal complaint was also received on so and so by one Srimati Nandita Das. She is from nearby town, my lord. They are from the city itself, from Horolupur. So she don't have any basis to complain. Selection of the petitioner stating that he had applied twice. The matter was thus examined by the authority and it was found that the allegations raised in the complaint that so and so is true. Accordingly, the petitioner's selection was cancelled against the application number so and so, and he was informed about the so and so. So without any basis, when it can be clubbed together, why they cancel my selection in the first draw? Application কপিগুলো আছে নাকি? আছে রেকর্ডগুলো কোন কোন কমপ্লেইন্ট জন্য ভরলে মতো আছে সব
And Lordship, there is an order passed by this court on 12/10/2023.
Read,
Lordship.
read the order.
This one court passed an order on 12/10/2023.
Read the order.
Lordship. We propose to examine the record to find out whether the applications filed by the appellant in petition number 325/23 were treated as distinct applications, which would have increased the chance of success in favor of the appellant unfairly. Mr. P. Bharatdas, learned advocate, representing the respondent number one
Have
to
you
three.
brought the record?
Yes, my lord, he has got the record of all the applications.
For the same location?
Okay.
For the same location, name is also the same, but it's other.
For the same.
They submitted online.
No, no, delegate application. I'm talking about other applications.
So
also.
if she has filed two applications, how is that?
Yes, my
Can
lord.
be considered even?
Yes, my lord. What happened, my lord? In the first application, he has given a different land so far, which is little bit far from the merger, that village, another village. Thereafter, when somebody told my lord, he realized, then he offered but from the same village, Jamla area. It is no doubt, my lord, he is the resident of that area. And if Your lordship will examine the other applications whether they are residents, because not a single person are resident of that village. He was selected and deprived. Others are not selected and no question of deprived. Because my lord, earlier he was selected, but on that ground he was, his application was, second draw was held. Then he was not selected at that time, my lord, because it's lottery.
Fine.
So, but my lord, as your lordship has the Ranat Singhal that has passed the order, other, they are in the list, my lord, but they are not fulfilling the criteria. So, my lord, if this is made again, my lord, and he has got all the applications, not only my two applications.
Yes, what do you want to say in your appeal?
Worship, so far my appeal is concerned,
Yes.
I raise my lord as per my lord appointment.
Your argument is that even though if you started residing in that area around 2 months before or 10 days before the date of advertisement, then also the respondents are required to consider you as a resident. Only this is what the.
And so far my lord, memorandum of agreement, I have already constructed go down and I invested huge amount. my lord,
Without any selection, you considered a go down.
more than 65 lakhs.
Without.
And the entire my lord, consumer are satisfied. I'm doing my lord.
When the letter of intent was.
And what is my fault, my lord?
It was?
The letter of appointment.
And now it has been cancelled.
And that cancellation also I have challenged by filing this.
Again, your application would be considered again.
And I filed a petition, my lord, and so far, my lord.
Resident name, eligible name.
And so far, my lord, order that at 7/12/2023, there is order that writ petition number 5781.
Yes.
It should be, my lord, 5718, because typographical mistake, it was not take, my lord. I pray to take the.
It was not tagged.
My lordship.
That
order was passed to take with this writ appeal, and but wrongly typed, my lord, because 5781, it should be.
Which is that order you are referring to?
7/12, my lord.
7/12.
7/12/2023. Because, my lord, I enter a agreement.
Heard along with 5781.
Yes, it should be 5718. Because my agreement.
This writ petition was filed by whom?
By my.
Challenging what?
Number 5.
Challenging what? You are claiming what?
Because, my lord, so far my cancellation regarding my contractual agreement, because contractual agreement and appointment has not been challenged by the writ petitioner. Even though my.
5718.
Yes, lordship.
That is not relevant to our case, my lord.
We cancel his candidature in compliance.
Against which he has filed there.
Again, he has challenged it.
Because, lordship.
But once the order is there to list along with that.
Lordship.
Then
But my lord, he prayed, that's why, my lord. Otherwise, that can be, my lord, acceptable because there is no consequence.
Learned counsel for the appellant lists these matters along with writ petition number on so and so. After hearing you, the order was passed, not hearing him. लिखिए. Coordinate bench of this court on 7/12/2023 has ordered for listing these matters along with writ petition C number 5781/2023.
But
Learned counsel for the learned counsel has submitted that as a matter of fact, the connected writ petition is 5718/2023 and not 5781/2023. Full stop. List along with writ petition number 5718/2023 on कब रखें? When?
Any date. my lord.
Same benches, my lord, because your lordship has heard, my lord, if possible.
Because I agree, because lordship, I have already entered agreement. And that agreement has not been challenged in the writ.
15th of February?
15th of April.
February. Sorry, 15th of February.
15th February. No. Today I have to get second adjournment all the hearing. 15th not possible.
16th or 19th, 16th February.
16th February also, my lord, I have got some difficulty, but next day I have got some function.
Then 21st. 21st.
Good, 19.
19, maybe 19 February, Monday.
We don't have any
Or-
problem.
No, my lord, if it is preponed, my lord, I have no objection.
19th.
Any date next week.
19th.
Any
My
date
lord,
next week,
I
my
have
lord.
some trouble, my lord.
Any date next week, my
21st, my
lord.
lord, 21st.
21st.
21st. I love that.
That's a motion, they're not hearing them.
Yeah.
21st is a motion there,
No problem.
22nd is a hearing day.
We'll hear all these petitions together. What's the problem in that?
No problem, my lord. Other courts have taken adjournments to do this, my lord. Whole day is gone here only. Adjournments, because when I'll be next, this matter will come up.
Remember.
That is the problem.
See to it.
Anyway.
Yes.
But they're fancy time, my lord. Still I am praying for your lordship. They're fancy time. They cannot be invited and given chance. my
We'll
lord.
hear you. Hear all the-
So many judgments are there. Next date, my lord, I'll come with return argument and my lord, judgments also. Fancy time cannot be, man.
Fine.
Obliged.
Item 23.
My lord, in this matter, my lord, the learned advocate general will appear on behalf of the state. Today, some difficulty, can it be on Monday? They are expressing some urgency. It was listed on their prayer. On Monday, my lord, it's not in-
Joint request, place it on Monday.
my lord. I'm obliged.
Interim. The interim order continues. The interim order continues, my lord.
Yes.
There was an interim protection, my lord, that continues, my lord.
Is that limited? Interim order, if any, to continue till next day.